Page number 2, item number 6 to 13. Page number 3, item 14 to 17. Page 4, item 18 to 23. Page 8, item 24. Page 9, item 25. Page 10, item 26 and 27.
Well, item 27, my lord. It's a writ appeal, my lord. I have taken only consent from the appealing parties, my lord. Already taken up 1 week after, my lord. What is the reason behind item 27, my lord? Why? I taken up 1 week after. My senior will argue this matter, my lord. He is not willing in accommodation. The request of Mr. Keswan and counsel attending to the appellant that the matter will be listed on 26th of September.
Page 11, item 28 and 29.
28. In this case, I am appearing on behalf of the opposite party staff selection. Earlier advocate, Mr. Shivani Das name, Pradhan name has been mentioned. So I pray I don't call this matter any other day, and in the meantime, my name may kindly recorded. I have taken consent of the petitioner. Item 28.
Have you? This is a part-time matter. That is the one difficult. Have you filed your memo of appearance?
Yes, I have filed my earlier order was also to that effect has been passed. But by mistake, my name has not been appeared because earlier Mr. Pradhan was appearing, and in the meantime, the staff selection and engaged me. So I pray my name may kindly recorded, and the matter will be taken up any day. I have taken consent of Mr. Mahanti, who is appearing on behalf of the petitioners.
All right. You are Mr. Jena. Mr. S.P. Jena and it. Counsel appearing for the opposite party number 3 has stated that Mr. S.S. Pradhan and counsel will not be appearing in this matter anymore. So this is directed to reflect the name of the Mr. General and Counsel as the counsel for the opposite party number 3. That the matter be listed on 21st September? 21st of September 2023.
Mr. Jena, there is an appearance memo of Mr. Pradhan. No appearance memo has been filed by you.
So then
and there is no order also that his name should be deleted and your name should be there. Which order you said that has been passed?
It was before the single judge, and it has been transferred to this one because the ultra-virus is in the order. Any of I will.
You filed the
yes,
appearance of whatever.
Page 22, item 38 to 30.
I am sorry to mention, Lordship, I am virtual. Item 29, can your Lordship take up this at 2 o'clock? Lordship, in this case, Learned Senior Counsel, Dr. Adis Agrawal is to appear. Can your Lordship take up this matter at 2 o'clock? Item 29.
Yes, we are passing over the matter for the time being. All right.
Page number 22, item 30 to 32. Page number 23, item 33 to 35. Page 24, item 36. Page 25, item 37. Page 26, item 38 to 41.
Item 30 on behalf of Mr. NC one is absent. He is not well.
31.
40. On behalf of Mr. NC South, I think one is after
40. Okay. You are there on record. You are Mr. Swine.
minor.
Yes, Swine.
Minor.
The request to Mr. S. Swine and Counsel that the matter will be listed on 27th of September 2023. Have you informed the counsel for the
Yes, ma'am.
respondent?
I have already informed.
Will inform you or you have informed?
I have already informed.
All right.
Page number 29, item 42. Page 31, item 43 to 46.
My lord, item 44, my lord.
Yes.
This is the apparent has retired in the meantime, and they already is suffering for pension, my lord. And your lordship last time asked for listed in the partner matter as a partner matter. So it may be taken up, my lord.
Today it may not be possible. Let it be there. We'll try. Otherwise, we'll take the matter tomorrow.
All right, ma'am.
Page number 40. Page number 32, item 47.
47, my lord. This may be taken up today.
If possible, if the time permits, be there.
Otherwise, I trade tomorrow.
All right, let wait for some time. Let us see what happens.
I'll go blind.
Page 42, item 48 to 52.
So item number 51, my lord. This matter, my lord, was listed on 22nd August and it was adjourned to 24th August and also directed to be taken up at 2 p.m. my lord. But on Friday, I have mentioned for which, my lord, this matter has come, but there is no noting that it will be taken up at 2 p.m. my lord.
Okay. You come at 2 p.m.
My lord.
Mark it at my.
Page 43, item 53 to 56.
54, my lord. My lord, before making any submission, my lord, I will be pardoned, my lord, for the last order. My lord, I could not comply by filing the counter affidavit. So, my lord, I'm extremely sorry, and I'm filing it before the honorable court, my lord.
Not in the court.
My lord, I will be accommodated for 1 week, my lord.
But this WPC number 9972.
972, my lord. I'm for the opposite party number 3, my lord, RATHO.
One affidavit was filed earlier occasion.
My lord, the counter affidavit was supposed to be filed on dated, my lord, 20th July 2023, my lord. And my lord, in
Mr. Where is Mr. Tripathi? He submitted on the last. You have supplied a copy to them.
my lord, I'm on behalf of Mr. Tripathi, my lord.
You did not file the rejoinder. You are for the petitioner.
My lord, I'm for the opposite party number 3, RATHO, my lord. On behalf of Mr. BP Tripathi,
Oh, BP Tripathi. Okay.
my lord.
No, on 27, 2023, orders from that, after affidavit will be filed in both of them.
Okay.
That compensation is not to be filed.
Yes, my lord.
So what is your prayer now? Today you will be filing?
My lord,
No, not in the bench.
I'll file it, my lord.
I'm taking the matter tomorrow. You file it in the.
My lord, today itself I'll file it. Well, highly obliged, my lord.
Give a copy to me
All
My
right.
lord, I'm submitting right now. That may be observed.
and also to the petitioner.
Yes.
Doge.
List it on the. So just tomorrow.
Highly obliged, my lord.
My lord,
Already after tomorrow. It has been stated that the counter affidavit could not be filed in terms of order dated 28/7/2023.
28/7, my lord.
20th, the page mark it is written 28/27/2023. So Mr. D. Mohapatra, learned counsel appearing for the opposite party number 3, has stated that counter affidavit will be filed in course of the day after supplying copies to the petitioner and the counsel of the
My lord, copy supplied.
of the other opposite parties.
local.
All right. Mr. You are appearing for 1 and 2.
This one, Housing and Urban Development Department.
Already filed because this is a mention hour, you supply the copy.
My lord, I have supplied, my lord.
All right.
All right.
Sorry, then Mr. Mohapatra and counsel has submitted that he has supplied Copies to the counsel for the petitioner and the opposite parties number 1 and 2.
And you serve to the petitioner.
My lord, I'll serve it. Right. To the
That is important.
Opposite parties
My lord,
number
I'll serve.
2 and copy of the petitioner shall be served in course of the day.
I will.
Yes,
Item 55, pattern matter kindly taken up today, my lord.
it will be taken up. Just wait. Just wait. Maybe it will take some more time. All right.
Page number 45, item 57 to 62. Page 46, item 63 to 64. May I be permitted to make a mention, my lord?
Yes, what is the, what are you going to mention?
Today's schedule is 30. I do not mention it when it was called. Your
Junior
one assignments. Number 30 and the appellant manner.
All right. You'll be there, I will let you try, but now.
I was standing in behind while coming to the front, the next page of the one. And Mr. Sorry, madam. Serial number 30 was. Right, Lord.
That order has to be passed regarding AD. Report of the registry. And some corrections about the order also. is done.
Correction in the order. It will not be 13. You are appearing for whom?
I'm appealing to the appellant's measure. Serial number 30. The read appeal.
You are not on record.
No, Your Honor, I'm not.
There are 3 other counsels are there.
Not in the.
What is his name? What is S. Paridal?
No, G. Corridor.
The request to Mr. G. Paridal and counsel, hearing on instruction of Mr. Shoma Misra and counsel for the petition. Let the matter be listed on 21st of September.
One criminal appeal matter that was listed Honorable Justice matter D-dash and escape pending. Where matter escape pending was appearing for the informant at Supreme Court. He is directed to place the matter because any other claim, that's the matter.
All right, it will just you send one of your associate to the registered judicial because it has to be assigned. No.
The Honorable Justice did.
I understand. One cannot take it up. It is an administrative order has to be passed, not in
Any
the
of the
judicial. No, not here. Registered judicial. You go to and file this mention memo to the registered judicial.
But I take permission from my lords to make a mention. In fact, one eminently urgent matters is being filed today, not even been numbered.
You have not filed.
But it's being filed. The reason
being filed is one thing, Mr.
I understand, my lord. But the urgency is,
urgency is there. File it and then mention.
But I was just requesting lords.
Because I know that you filed, that I have filed and mentioned now will allow you if it is so urgent. But unless it is filed,
take liberty to disturb your lordship.
No, this cannot happen in the court. That I will file and you now fix the matter. That will never happen in this court.
Lord, I am filing it. Lord, I
filing it, just you mention when you file it.
Right.
If it is so urgent, you will take up. Otherwise, not take up. Yes.
My lord, Relief Appeal number 1742 of 2023. Appellant is going to be disposition from his land and building by the respondents. They have given ultimatum on 1st September.
By whom?
Kindly taken up.
By whom?
By the respondent number 3 OPTCL.
We do not know. That is not on board. You tell who is the OPTCL. You do not know anything. The record is not before us. You tell who is the OPTCL.
And giving
You tell how it is important, why they are going to just evict you.
Without giving due compensation, they are evicting.
There was acquisition also?
No, not
No, there is no acquisition. There is a land acquisition,
Yes,
also,
yes.
not before this bench. There is a assigned bench. You go there and mention it.
I should pardon to mention that. Pardon.
Is it a writ appeal?
My lord.
Is it a writ appeal?
Yes, yes, writ appeal. Writ appeal.
I don't know how it can be urgent. When have you filed the writ appeal? No, this all. When you filed the writ appeal?
Writ appeal, last, no, exactly date I do not remember.
We have to remember this date when you filed the writ appeal.
Writ appeal last, second, last week I have filed.
Yes. Take it there, just check out. Let us see. The list before me, what is there written in the
One.
Where is the council? Is left. Already, you bring the brief before me, huh?
But pardon to mention that, Melchi, there is a PIL matter, Melchi. That the direction, Melchi, I only pray before was a direction to the opposite parties for civil and criminal action against the opposite parties. They have the opposite parties have the grab the and misappropriate the government money that has been funded for the minor irrigation project, Melchi. And the inquiry report has been already filed, but they have not followed the such inquiry report, Melchi. I'll only pray for that matter will be listed tomorrow, Melchi.
All right, you go to the local, talk before us.
And I have filed the writ of PIL, Melchi.
We are not looking. We have no power to inquiry into matter. Go to the
My
local.
representation also, that is my representation also is pending, Melchi. And
all right, will come day after tomorrow.
23314. 23314, your lordship's specifical directed the matter to be listed on today, but the matter has not been listed. May the matter be taken up tomorrow because that is an urgent matter.
Day after tomorrow, it will come. You send the mention memo.
Pardon to mention, my lord, see, it is a lease matter. It was listed before the Honorable Court number 3. Honorable Court directed that this matter be put on immediate list. When I permit to
register, mention before register judicial.
Pardon to make a mention, my lordship. When I criminal appeal 42 of 2019, when I nomination bench. Nomination bench, my lordship. It was earlier before Honorable Justice Siadas and Honorable Justice MSF. But it was directed to be listed before Honorable Justice Siadas and Honorable SAVITRI. Honorable Justice SAVITRI. It was clearly mentioned in the order sheet on 29/3/2022.
That's all right. You mentioned before the registered judicial.
I've taken several steps, Your Lordship, but it was not.
Then take it. You have written that you have mentioned earlier before the registered judicial. Write it, give a note, then only you will take up it. Okay.
My lord, one single bench contempt matter assigned to court number 22. My lord, the honorable court number 22 refused to hear this matter. Now I pray for assignment, my lord, or any other bench.
Why?
He has refused to hear this
matter. Go to the registered judicial. Refused or recused?
Refused to, my lord.
Recused. Okay, go to the registered judicial.
Actually, in the PL, 21st/9. Actually, this is an ongoing project, and which is already continuing, and it will be too late if the case will be here on 21st/9. Then need the earlier.
Mentioning for listing.
Which case? When the matter was directed to be listed?
It is listed on 10th August to 21st September.
10th August, you were not there. That is why it was adjourned.
Actually, at that day, my serial number was 51.
Oh, it did not reach.
Yeah, yeah.
Okay.
Just bring it early. Okay, it will be taken up in this week.
Number five.
Just to track the cost list.
26.
All right.
Make on the list. Weekly list, fresh submission item number 1.
Your Lordship, pardon, Your Lordship, appearing on VC, Your Lordship. Your Lordship, on behalf of Dr. Lenka, Your Lordship. Your Lordship will seek adjournment for correcting the defects, Your Lordship, removing defects, Your Lordship.
You are not on record?
No, Your Lordship.
What is your good name?
Lakshmikant Tripathi, Your Lordship.
At the request of Mr. Lakshmikant Tripathi and counsel appearing on instruction of Dr. J.K. Linkal and counsel appearing for the appellant, let the matter be listed on 27th of September. Meanwhile, the defects as identified by the registry shall be removed. Appearing for the state.
State, in fact, does not sought the copy of the state appeal.
You sought the copy of the memo of appeal to Mr. Muduli. Mr. P.K. Muduli, learned additional government advocate, has appeared for the, I think, all the opposite parties, right? All the opposite parties? Oh, you have not a copy.
I'll serve copy, Your Lordship.
The engineering chief is an officer of the state.
All right, engineering chief, additional chief engineering and superintendent.
Yes.
How this readable is maintainable without making the state, you are making the officer of the state parties?
Your Lordship, I have no instruction on the matter, Your Lordship.
No instruction, tell your senior that on the, if it is not cured, we will dismiss the petition.
Your Lordship.
All right. For all the opposite parties, we are recording it.
Item number 2.
The counsel for the petition is directed to supply a copy of the memorandum of appeal to Mr. Muduli and counsel in course of the day. Yes.
Item 2.
Item 2, my lords, kindly pass over.
Okay.
Item number 3.
My lord, directed me to obtain instruction. Received the instruction just now.
Necessary matter pending and necessary unauthorized occupation of a store.
Possible, but
To remove the defects.
that one will keep on this, just inform the council also. Yeah. First matter, it is on 11th of August, okay? Not 21st, 11th of September. Inform the council, huh? Like, change.
Item 1.
Man. Item 2 pass.
Can you give a copy to Mr. Ralph? This court can do nothing. Just see. There is civil litigation pending.
Civil litigation, as it appears that it is.
Civil litigation 13892 already dismissed, madam. 13892 dismissed.
Yes, madam.
Till disposal of the civil suit numbers also. You have indicated that it is disposed of.
Intentionally, the authorities are kept pending illegally.
So what is the, then if I thought that is till disposal of the order dismissed by the, but the suit is whether about suit you do not know anything.
That is disposed of, is mentioned.
Where is it written, disposed of?
Your Lordship,
In your instructions?
it is with the trustee till disposal of civil suit numbers one.
No, you are saying it has been
You are
disposed.
saying civil suit has been disposed of. Where do you get that?
It is there.
Where?
In paragraph 4, in reply to status of execution of order dated 5/3/2000.
4 is not here. We have only
Paragraph
3.
Paragraph 1.
Alright.
In
Where?
reply to status of execution of order dated 5/3/2004 passed in sealing case number 47 of 1974, the deed and revenue officer Konika has passed order to examine the record which has been recorded in the name of sealing holder, excluding the land transferred by virtue of registered sale deed. On 39/2013, the deed and revenue officer Konika has passed an order to keep the land relating to Botanical Garden and Konika Museum as it is with the trustee till disposal of civil suit number so. Oh, this is an order to, yes. Yes. Pending.
No, but has that order dated 39/2013 been quashed by the High Court in OJC number so and so? It can't be because OJC is before that. No, can't be. Can't be because that is a. So what has been quashed by the in OJC and SLG? Sealing case?
No, the only sealing case order was challenged by the.
No,
sealing is not challenge.
Earlier the same has been quashed by the Honorable High Court. Earlier same is what?
Madam, the Botanical Garden Trust, one trustee and Konika Museum Trust.
No, just a minute. The same has been quashed. What is the same?
Not clear.
Order dated 5/3/2004.
Quashed. In fact, the pleadings made in the repetition that has been confirmed.
That is a confusing statements are there.
Yes.
Instruction if you get, it should get complete, not part.
While coming to court, I received this.
The repetition.
The incumbent is a new incumbent. Recently, he has joined the post. So Saturday I contacted him, and today morning he has sent the instruction.
You are getting explanation when we ask for explanation from the section. They will say we were busy with various cases. That is why the mistake was committed. But time of the court is being wasted.
Yes.
But our order dated 2/8.
Yes.
Is a information is sought whether in the selling surplus land you have settled in anybody's name.
That last
The minor directive is paragraph 3. Minor directive whether in terms of order passed in sealing case, the record of rights has been created or not. That he has stated that it has not been created.
Paragraph 3.
In reply to such instances,
Some persons have been allotted settled land.
under 36A.
Yes, under 36A of the OLR Act.
Have you got a copy, Mr. Raut?
Yes, madam.
We are taking up the matter day after tomorrow. You come with a detailed thing, what is happening, no? Because in para 3 they are saying there is very quick, and Mr. Mudoli, that you have to elaborate things. Who are those persons?
You give a detailed report within 2 days. Let him.
Yes.
There's the material listed day after tomorrow. So in the meanwhile.
Look, can it be 1 day more? 30th is a state holiday. 30th is a state holiday. Can it be 31st?
All right. 31st December. In respect of the petitioner shall respond to the instruction of Tahsildar Kanika as filed today through Mr. T.K. Muduli, an additional government advocate. A copy of the said written instruction has been supplied to Mr. B. Raut, Learned Counsel to the petitioner. We would direct the Tahsildar Monica to give a detailed report. You are the person who have been settled on the selling surplus land, whose reference has been made. Oh, though the reference has been made regarding the granting settlement, but their details are not available in the instruction. Stop. We also direct him to furnish details. As Mr. Raut, counsel to the petitioner, has stated that civil suit number 138 of 1992 has been disposed of and its judgment in order have reached their finality. Stop. Whether any action after the disposal of the suit has been taken by the office of the Tahsildar. Tahsildar, in compliance to the order dated 5/3/2004, passed in Whaler Sealing case number 47 of 1974. So a copy of this order be supplied to Mr. P.K. Muduli, an additional government advocate. The written instruction is produced before us, is taken on record.
Commissioner, due to the non-creating the record of rights, number of sellers, minimum 23 sellers shall be executed.
That is why we asked the after disposal what action they have taken.
Yes.
Item number 4.
Lordships.
Yes.
So this is a public interest litigation, Lord. Petition, Lord. The petitioner has filed this application challenging the illegal formation of the corporate society in the two panchayats. Government's action for construction of a establishment of a corporate society in two villages, that is village Tundra Gram Panchayat and Inchud Gram Panchayat below. But what is some persons that is the behind the back of the without knowledge of some villagers of the two panchayats below, the society has been formed.
What is your right?
But it's
in a society or cooperative society, every person has the right to know that we must know, otherwise society cannot be formed.
Yes, but some person's name is there. They don't know what is the fact. But there's some
representation to the society.
Kindly see the prayer.
I've seen the prayer. That is why I'm asking you these questions.
Yes. They are challenging annexure 1. Society in favor of who this annexure 1 has been issued, but they are not the parties here.
Okay.
Sindhura Gaura Service Cooperative Society Limited.
Oh, they are not party also.
No, here they are not parties.
But
assistant but you withdraw this petition.
Assistant Registered Corporate Society already made party.
Huh?
Already made party.
Cooperative society, but whose registration you are challenging, that cooperative society has not been made party.
Oh, sir, he has not made party, but so many persons are there.
And there may be statutory remedy also.
The remedy is there. First of all, where is your right? Suppose in this room there are 11 persons, because 11 persons is required to form a cooperative society.
Yes, ma'am.
We form a cooperative society. The persons in the other room may not know it. Whether they do have any right to ask that why a cooperative society had been formed without my knowledge?
Because some irrigate there, that is why not open to
part of all, you are not part of this society. If some legal infirmity is there, you file an application to the registered cooperative society.
Already made, but
already go there, pursue there, because you have not made that society a party.
Show me person there, that is why I did not.
No, the cooperative society only there, by name cooperative society may be made party. You have not done that.
Yes,
withdraw the petition.
But may permitted to amend the cost title so that it will be.
No.
But the public to file with application.
But rethink it. At the request of Mr. C.R. Patnaik and counsel appearing to the petitioner, we allow the petitioner to withdraw this petition. So if circumstances so requires, petitioner may file any other, may go for the appropriate remedy in the forum relevant for that. Okay. Mr. P.K. Muduli and petition government advocate has appeared for the opposite part. Next.
Item 5.
Your Lordship,
yes.
The petitioners have challenged the shifting of hospital from the existing place to a different place, which will cause inconvenience to the people of that location. So already the hospital is there at near in Khurda district of Odisha, and the people are facing people will be facing problem due to the shifting of this hospital from the existing place to a place which is located at a distance of 2 kilometers. Particularly women, the bank people will face inconvenience. The present location is suitable for expansion as well as infrastructural development. So the petitioners have already put their grievances before the authorities, that is BDO of the concerned locality, to the CDMO of Khurda district, to the private secretary of Chief Minister of 5T, and also to the collector Khurda. But they have not given any reply to the representation made by the petitioners.
What is your representation?
Your Lordship, next number 5 to the CDMO Khurda, page number 22 to 26, and next to number 4, page number 20 to 21 to the Block Development Officer Khurda, and next to number 6, page number 27 to 31 to the Private Secretary to the Chief Minister of Odisha, Secretary 5T, and next to number 7, page number 32 to 37 to the Collector Khurda. That's your Lordship.
You are there on record?
Pardon, Lordship?
Are you on record?
Yes, your Lordship.
What is your good name, sir?
My name is Amya Hussain Das.
Mr. Das, we are asking you to give the representation to the Secretary Health Department. You will decide. It is a matter exclusively related to the policy. We cannot decide from the court.
Yes, yes.
Right. Only one, Principal Secretary or Secretary?
Principal Secretary Health Department.
All right.
And in fact, your Lordship may kindly say.
No, we are not observing anything. He will file a representation for shifting. They will consider and dispose of. This matter we are not going. There's whatever.
Because this work order was issued in the month of September 2022. Now, after 1 year, virtually after 1 year, he has approached this honorable court.
So why you are late by 1 year?
And second thing, your Lordship will see from page 19, serial number 2732. At the center in question, the column, 6th column, your Lordship will kindly see. Serial 2732. It's at page 19.
Yes, sub-center.
Sub-center near the next column.
No.
Sixth column. Whether physically located as per location name, yes or no?
Yes.
You Lordship, the remark is no.
Okay.
So since it's not located at the particular location, that's why a decision has been taken to construct at the particular place as per the name of the sub-center.
Okay.
And that work order was issued in the month of September 2022. 5/9/2022. Your Lordship, the current location is suitable. The new location will cause inconvenience.
We have to settle the location for the government. The land doesn't belong to the court. The administration doesn't belong to the court. Finance doesn't come from the court. They are to taking their own policy according to their assessment. We are not here. If you have any difficulty, we are giving you the opportunity to file a representation.
Okay, your Lordship.
heard Mr. Omio Bhuchandas and counsel again for the petition by means of this public interest litigation. The petitioner has urged that the shifting of existing health subcenter at Niala to a new place. Urge this court maybe urge this court to prohibit the opposite parties from shifting the existing health subcenter at Niala to the new location, as that will deprive the residents of Malipur, Champapur, and Niala Mojas of Khordha district. Stop. According to Mr. Das from the council, the women and children in particular, women, children, and the Divyanga population will suffer a lot for such shifting. Mr. P.K. Muduli, Learned Council, has submitted that the tender for construction of the new health subcenter was floated on 5th September 2022. Stop. Yes, yes. Even it will be difficult to reconsider the matter. Without a seat, we dispose of the writ petition, we giving liberty to the petitioner to file his grievances to the Principal Secretary, Health Department, Government of Orissa, within 15 days from today. After such representation is received by the Principal Secretary, Health Department, he shall dispose of the said representation within 3 weeks from the date of receipt. No adverse to cost. Yes.
Item 6.
No, please, your lordship. Lord, this is a PIL. However, the petitioner to save the gotcha land mentioned in the schedule of the writ petition, which has been illegally converted to Abad Jagya Anavadi to Kisan Patit and then handing over to operating partner 4 by annexure 4 by the Tahsildar of the number 3, Lord. I'm saying illegal because it is in clear violation of the Article 44 of the 5th schedule, Article 5.5 of the 5th schedule of the Indian Constitution, Lord. Let me read out of the Constitution that have rule. It says, Lord, no regulation shall be made under the paragraph unless the governor making the regulation held in the case where there is a tribe advisory council for the state consulted such council. So, Lord, the National Council there, and they say that unless a Gram Sabha is to be made, they cannot take any decision over the land, Lord. And here, the crime, Lord, by the local government, Lord. The OP number 3, he said that I have given a notice for an invited objection, which was to be seen under annexure 6, Lord. 6 at page 32, you also see. He says that I have issued this letter, and this is in Odia, my Lord Justice Ratho will help my thing, Lord. Here, in annexure 6, you will see, they are giving the model correctly, making the name Sanaga and other things correctly, whatever the students are giving. But if the address to whom, you will see, if there are major this is Sanaga. And Sarpanch under Lecture 8 of that he has said that we have not received any such letter of objection from the Tahsildar or from the authority union, and that is to be kept because this is a land of Gochar land reserved for the people. So this is thing, and you will also see for that reason that the entire land is to be given to IFCO now by the operating in the understanding of the My response submission is under that we want to status quo. Why the party is not?
You're referring to Annexure 30, Annexure 6?
Yes, my lord.
So that has been given by the Tahsildar.
The Tahsildar and presidency too. This is given. But this is the Samaga. And here the schedule below, they have mentioned my land. Of Samaga, but they have given the address to a different village.
On the top, but in the bottom it is written Gram Panchayat Karjalaya
Chikatmati. That is true.
Yes. So Gram Panchayat is correct.
Gram Panchayat is correct.
That GP. Let me saying my response submission is that your lordship may kindly see there is a conversion case under the OGLS Act. Tahsildar invoked its jurisdiction and allowed the conversion case, and this is the notice issued in conversion case number 4 of 2021. The final order of the conversion case, by virtue of which the patta was corrected from Gochara or something else to Abad Yogya Anavati, that order is not annexed. Now he is saying that in the conversion case, there are certain irregularities committed by the Tahsildar, and that order is therefore non-annexed, and the consequential patta, the conversion patta, which was issued pursuant to that order, should be quashed. My response submission is that Tahsildar order, he has not annexed to the writ petition.
But the notice, if it goes to the wrong village, how the damages?
That is what I am saying. That is what I am saying. If there is any irregularity in that order can be appealed before the sub-collector. Not that the Tahsildar has passed the order since 2021, 2 years back. Patta has been corrected since 2 years back. Now this PIL is filed challenging the order of the Tahsildar, purportedly challenging the order of the Tahsildar past 2 years in 2021. And saying that there are certain irregularities, the notice doesn't say the name of the village, although the Gram Panchayat name is correct. What my lord has rightly pointed out.
Don't you file a regular appeal?
Yes.
That's all right. You just go for the regular appeal. If you succeed in the appeal, you can also ask.
One thing also you see, in the scheduled area, this is clearly alternative harassment because this cannot be done without the approval of the Gram Sabha Lord. You let see Annexure 6, Annexure 9, where the National Council is clearly given order by Dr. Mandasai. Here also you see, he has clearly said, and that has been given to the governor and the chief secretary also. And the reading order by Annexure 9.
My lord, at some point, my response submission is that either he should file appeal or he should approach the Tahsildar to recall, because that order stands. That is not challenged in this writ petition. By virtue of that order, the patta has been issued. You have challenged the patta, but you have not challenged the order basing on which the patta was corrected and the conversion was allowed.
First of all this conversion, all these things, that should be done only after being passed by the Gram Sabha. That is the law.
Maybe. But if there are certain irregularities, you have to point it out before the appellate authority or the same authority by filing a recall petition.
Okay, let them file the counter.
We can't file any counter.
No, we go to the appellate authority.
Yes.
No, you also see. If that has been clearly violated the ultra virus nature, you also see dimension 9. That is the side there. He has issued this letter, and what he has told, he was I'm ready for paragraph 2. The Environment Protection Act.
Yes. So this context, Section 58 is the appellate power under the OLR Act. Section 58.
Because here it is clearly said, the National Commission of Scheduled Tribe, the constitutional body, set up to safeguard the interest of scheduled tribe and deliberated on the subject and is deeply concerned about the fragile life of the scheduled tribes and the hazards which are likely to be caused on account of the displacement from their land, the setting up the industries, particularly in area coming under Schedule 5 of the Constitution. It is the background that the Commission has recommended to the Ministry of Environment and Forest. There is all cases of environment clearance and heavy industry to be loaded. In 5 areas, tribal areas, the following should be essential component of the social impact assignment background study before any public hearing is concerned. So, let's see. They have given a public hearing in a different way. So, this is the condition. Also, the detailed of my National Institute of Reference of all aspects of health and reference given tribe block, the detailed quality of drinking water, the study of the central position, central board is further the consent of the Grand Sabha. Here also is clear. Further, the consent of the Grand Sabha of the village in the area of the project is proposed to be located. So, necessarily, we obtain because any public hearing is pointless. If the villages are not keen on relocation, this would be in accordance with the spirit of the Panchayat. Extension to Schedule the respective state government should redirect it to make the consent of the Gram Sabha mandatory in Schedule 5 areas. The Commission recommended that in exercise of the special power vested under Article 244 of the Constitution, upon the Honorable Government Schedule 5 states you should kindly direct the state government concerned that only after the aforesaid procedure of a social impact study with proposed investigation study and mandatory Gram Sabha consent is taken, should any public hearing be undertaken under the Environment Protection Act. I hope you will appropriate directions in the appropriate measure. And definitely, you will also see in Annexure 9A, where the personal secretary of the government issued this letter to the secretary. I am directed to send here the copy of DO letter number such and such to 17 May 2018 of Dr. Mandasai, chairperson, National Council for Scheduled Tribe, Government of India, the address to the Honorable recommending such an essential component to including the major aspects of making the content of the Gram Sabha mandatory before taking public hearing in Schedule 5 area, where ST people are likely to be affected by the proposed industry to be set up in scheduled area. As detailed by the Honorable Government steps may kindly be taken for implementation of the recommendation of the National Council of Scheduled Area. That really mentioned, and they have no right to come without a Gram Sabha, without a public hearing, everything. That was in a different way. Therefore, the consultation of and so that's the entire Gochaman the cattle of the poor villages of grazing that has been now we will convert.
They can be given liberty to urge all these points before the appellate authority.
If this ultra virus is nature, I think
it cannot be ultra virus.
Because order can be ultra any such action. So yes, if the no Gram Sabha, nothing. You shouldn't five clearly violated.
Well, this will come under 58 according to you.
Yes, because your lordship may see section 8 capital A.
No, just
conversion.
This
conversion was allowed in exercise of power under section 8 capital A of the Oiler Act.
Yes.
That is applicable under section 58 of the said Act.
The Oiler Act.
Oiler Act.
The conversion has been done under section 8A.
Oh, sorry, 8A.
And all the conversion is done after a public hearing only. Public hearing, and that public hearing is done after Gram Sabha.
It is for the conversion of the agricultural land, and according to the Gochol land, there is a different.
8A refers to agricultural land.
Agricultural land. Yes. Any conversion proceeding is
this is Gochar land.
Related to Gochar land.
Gochar is under section. I am sorry. Gochar is under the OGLS Act.
Yes.
OGLS Act. I am sorry. Section 3. Yes, that is also appeal provision is there.
No, appeal provision, but you don't have to give notice to the villagers.
No. That yes, maybe.
Sent to wrong village, so that not affected.
You may see that is their allegation, but
that's reflected from that annexure 6.
That can be examined by the appellate authority. That is my response submission. That is under the OD, since it is.
What can be examined? Whether it went to the.
There is any proper
Are you
notice.
disputing that this annexure is incorrect?
No. The appellate authority can also examine whether the notice is proper, whether there was any proper.
No, on the face of it has gone to a wrong place, wrong village.
Then he may be permitted to approach the Tahsildar for recalling of that order on that ground.
Not one will, I think
that order. See that order is not annexed. That is the only difficulty on my behalf to address your lordship.
You just bring that order on record.
Yes, that order may be annexed.
Mr. Namtra, you bring that order on record. The order of this,
allowing the conversion.
The order allowing the conversion.
Okay, 1 week at least, your lordship will give 1 week after letting the matter come. I am the status quo matter because the IDCO people, they will, that are government agency.
This is for developmental purpose we have given to IDCO, and these are only.
So you can't democracy sold on these poor innocent people.
We are concerned about the poor people, but we have to also follow the procedure.
It's not. It is.
Socially abiding order that I had to follow the procedure. But what they have done,
challenging an order before the court where the order has not been placed before.
Okay, let it come 1 week after.
This is a reasonable submission.
1 week after, let it come.
We are fixing the matter on 12th of September.
Okay.
Alright.
12th of September.
You heard the request of Mr. Ghaneshwam Namthwal and counsel appearing to the petitioner. Let the matter be listed on 12th of September 2023. The order by which the conversion has been allowed by the Tahsildar has to be placed on record for its examination. Stop. It has been stated that by invoking the provisions of Section 3 of the Orissa Government Land Settlement Act 1962, a gochar land has been converted for purpose of
Abad Jogyo and Abadi.
Abad Jogyo and Anabad Jogyo land. Stop. Mr. Namthwal and counsel has submitted that since the said land is in the schedule area without public hearing as regards the opinion of the residents of this scheduled area, such order of conversion is grossly illegal. Stop. We would request Mr. D.K. Mohanty and counsel to take instruction from the concerned Tahsildar whether any such of hearing was organized in the concerned village. The name of your village?
Sanwaga. Village is Sanwaga, my lord.
Village. Stop. Let us take on 12th.
My lord, item number 2.
Section 3A.
My lord, item number.
The reservation is 3A. It is Section 3A has been
the OGLS Act. I will come with full preparation on the next date regarding the conversion of gochar land and the provisions of law, everything.
Section 3A.
My lord, item number 2. The lordship has passed it over. Now he is there.
Cannot status quo be maintained by the party, my lord?
No, Mr. Mohanty, I asked the Tahsildar to look into the matter. Let us have the blanket status quo creates more problems than solutions.
Without getting any record, without ascertaining the position, how he's.
Yes.
Well, item number 2, your lordship has passed it over. Either your lordship may take it tomorrow or there is a point.
I'm there, Millet. I'm sorry, Millet. I was.
Today also,
It's a very short issue.
What also I got the decisions.
I have supplied the decisions, Millet.
Let it be taken up now.
Yes, I'm ready.
Okay. Yes.
Yes, my pleasure. Item 2. Millet, the writ appellant challenges the order of Honorable Single Judge Millet, where in the writ petition, the order of Planet National Green Tribunal on the challenge Millet. And the Honorable Single Judge declined to interfere on the ground that there is an appellate provision, Millet. I approach before your lordship in 2 counts, Millet. The power of your lordship under 226 is not outstood or not been specifically denied under the statute, Millet, even if there is an appeal. And I place the recent judgment of Honorable Apex Court, and there are other judgments.
There is one other issue. What is the bench that passed this?
Eastern bench, Millet, which is
then the jurisdiction is only of the Calcutta High Court.
No, Millet.
Some matter is now being adjudicated at Kolkata. Only thing the Honorable Single Judge has said that alternate appellate.
No, that is a separate. This is a appellate.
No, Millet, it comes within your lordship's jurisdiction, Millet.
How do you say that?
Millet, Orissa, the National Green Tribunal Eastern Zone deals with the issues of Orissa also. And Millet, Orissa High Court has got jurisdiction over the Eastern bench.
Are you sure?
Yes, Millet. And there are judgments where, Millet, there are 2 lines of doubt
because the principal seat in Delhi.
Yes, Millet.
It is only jurisdiction with the Delhi High Court, though it is a national.
No, so far as the Calcutta bench is concerned, all the orders are being challenged here because this is the Odisha matter is under the jurisdiction of Kolkata.
Millet, that question was raised before Honorable Apex Court, where Millet, it was in Bar Association case, Millet, where
2023 decision of the Supreme Court.
Yes, Millet, that in that also it has been dealt with whether the bench of the learned tribunal has to be in the principal bench under the principal bench of the Honorable High Court or not. It has been dealt with, Millet. I have the copy, Millet. Where, Millet, if the tribunal has been constituted taking the territorial jurisdiction, even if there are different states, Millet, the respective state high courts will have jurisdiction because the Millet tribunal is always subordinate to your lordship's jurisdiction, Millet.
This is all right.
That is Kalia Sati case.
And our Honorable High Court and your lordship, if I permit, lordship permit me, I can pursue your lordship by a recent judgment of Honorable Allahabad High Court, where the same issue. Yes, yes, Millet. Millet, Madhya Pradesh High Court Advocates Bar Association.
See, just read the relevant part on.
Millet, if your lordship may kindly have page 14, Millet.
Page 14.
Page 14, paragraph 38, Millet. I have put 2 sets, Millet. My place, Millet? In consequences of the above analysis, Madhya Pradesh, Millet, decided on 18/5/22, Madhya Pradesh High Court Advocates Bar Association and others versus Union of India. Paragraph 38, Millet. In consequence of the above analysis, our conclusion are National Green Tribunal under section 14 and
page number you are reading.
Page 14, Millet. There are 15 pages, 14 of 15.
Last but one.
Yes. The National Green Tribunal under section 14 and 22 of the NGT Act does not oust the High Court's jurisdiction under 226 and 227, as the same is a part of the basic structure of the Constitution. The remedy of direct appeal, Supreme Court, so and so, is intra vires. Yes, ma'am.
Jurisdiction regarding order or directly regarding the list?
I beg your pardon.
Please read that paragraph again.
Against the order of the NGT, final order of the NGT. That is the Supreme Court's view, I think.
Yes, madam.
Well, it's, if the Lordship will see, this Honorable High Court has also dealt with the same issue in Kalia Sethi and others versus State of Orissa. Well, it's at page 10 of 15, well, it's page 10. Yes, Manoj. The National Green Tribunal Act does not specifically exclude the power of High Courts under 226 and 227, though it excludes the jurisdiction of civil court as provided under section 29, but there is no express exclusion of jurisdiction of the High Court, Manoj. In section 22, National Green Tribunal confers power to appeal to Supreme Court through any person aggrieved by the award, decision or order of tribunal. The same is almost like a second appeal on substantial question of law. And this case, my lords, this Honorable Court interfered with the order of the learned tribunal and modified the same, holding that this Honorable Court has the jurisdiction over the National Green Tribunal. Okay. And recently, my lords, Honorable Allahabad High Court has also dealt with the entire issue and held that your lordship has the jurisdiction. And more particularly, if your lordship can take one.
I have no confusion about 226 to 227 jurisdiction.
Yes,
the territoriality, that is the issue. That is
my lords, may I submit, if lordship may kindly appreciate, the territorial issues with regard to Orissa High Court will come to before the National Green Tribunal Eastern Bench. And if at all, for a second.
I'm giving you a parallel example. Yes. In the Central Administrative Tribunal.
Yes.
The Central Administrative Tribunal is a national tribunal for purpose of the central government employees. When its final order is passed, where the 226 judicial review lies, in which court? All courts, because suppose a person goes from Orissa, they'll lie before the Orissa High Court?
Yes.
No, there's a specific decision. Right now, I cannot remember that it will only lie before the Delhi High Court. Mr. Mohanty, I think this is a judgment. Only before the Delhi High Court.
So far as this
As far as this National Green Tribunal, if a person can kindly excuse me, then no National Green Tribunal for any state. So the Eastern Region National
bench
is there at Calcutta. So against the order of that, if it is a case from Odisha and the cause of action is in Odisha, then it will lie to the Odisha.
No, that is there. Ordinarily, we apply the territoriality that way. But I am asking Mr. Behra that whether there is any judgment of the Supreme Court restricting to the concerned High Court. Because the Central Administrative Tribunal matters are all from different states.
Remembers that income tax tribunal case, my lord, though it related to the Central Act, the Tamil Nadu government entertained it and passed it, telling that the High Court's inherent jurisdiction cannot be curbed.
Cannot be curbed.
And I think all these decisions are based thereafter, on the basis of the income tax case.
That Kalia Sethi case also of Odisha High Court.
Yes.
And that our own High Court has decided that this court has the jurisdiction. Kalia Sethi versus.
Okay, that is not disputed. The question from my lord is that what would be the territorial jurisdiction? That is the question asked for.
So why without filing the appeal you are coming to the judicial?
My lords, here, my lords, another leg of my argument is, my lords, on merit also, that I pray, my lord, there was a violation of natural justice. I have not appeared, I have not made my stand before the tribunal.
You are not served it.
Well, we are served, my lords. We had reasons for which.
So now the denial of
second, my lords, lordship may kindly say on merit. The order has been passed against me, even though the state government has categorically stated and given a report in my favor that there is no violation at all. My lords, lordship may kindly have annexure. The inquiry report
without admitting that we are issuing notice, pre-admission notice. All right. Heard Mr. P.P. Behral and counsel appearing for the appellant. Issue pre-admission notice.
And the impugned order is only on the ground that alternative remedy is available. That can be examined by the Honorable Division Bench.
Yes.
And on that point, your lordship can admit on whether the.
No, we are issuing pre-admission notice. We will take the hearing.
Yes.
Admission stage will hear the matter.
Yes, yes. Because there is no response to be given by us. Now it's only on the point of law.
Since Mr. D.K. Mohanty, that counsel, appears for the 1 to 8, I think you can appear.
No, my lord, I am just now I am giving.
Except state pollution control.
That collector is the only, your lordship can issue notice to the collector because opposite partner respond number 7 and 8, collector and tahsildar.
Principal Secretary to the Government of Panchayat Raj Department.
Your lordship may not, because we are contested.
Collector has to take, accept the notice.
Yes, my lord. Yes, my lord. Then 5 also.
1, I think 1 also can you accept. Assessment committees are under the state government.
Yes, ma'am. 4 to 8.
Yes. The response is about 4 to 8. No formal notice is called for. Respect to those respondents, the applicant shall take steps for service of notice on opposite the respondents number 1, 2, 3, and 9 by registered post with 18 within 3 working days from today. Notice is made returnable on 27th of September 2020.
May I humbly pray, my lord, sir, to protect, because I have paid the entire royalty, entire amount, and I am not being allowed to operate, my lord.
That order, paragraph 2, that the collector in miscellaneous case number so and so has prohibited.
We have filed the joint inquiry report. That is most important.
Next phase 1, yes, ma'am.
That was until the next day.
Minutes, all I pray minutes. I have kindly just
in the form of interim order, we cannot dispose them.
Kindly protect me, because my lords, the order is, I mean, the entire inquiry.
The consent to operate has been recalled by the State Pollution Control Board.
No, they have directed to recall it.
They have directed. That is why they are not allowing me to operate. Lordship,
kindly 6 months it will be. A particular period has been given.
I think they have already, because he doesn't have the consent to operate.
The EC is there. It is directed that the EC may be withdrawn within 6 months. That is the direction of the tribunal.
Then no order is necessary. If nothing has been done, no order is necessary to protect him.
My lordship may kindly observe that, at least, because my lords, because of the
order, even just if the respondent number 9 is not to recall the consent to operate,
I'm so grateful.
That shall not be recalled till the returnable date.
I'm so grateful. 9.
After State Pollution Control Board is the authority to provide this consent to operate.
Sir, let maybe checked off, because
State Pollution Control. Yes.
9 State Pollution Control Board. They have to give this permission under the Pollution Act. Next.
Item number 7. Item 7, Lordship, the OP number 6, the Orissa State of Technical Education and Training, along with the government, has started an e-health and telemedicine program, and the petitioner was selected as entrepreneurs for the said program, Your Lordship. And in the year 2012 it was started, but suddenly, Your Lordship may kindly see page 49. Page 49.
Yes.
The government decided that this is regarding telemedicine network through OPED. As per the decision taken in the meeting held on 13/5/2014, no new telemedicine center should be opened until government orders. This was the subject matter challenge before this Honorable Court, and this Honorable Court granted interim order, stayed this order. Against the interim order passed by this Honorable Court, the state approached the Honorable Supreme Court, that is page 51.
Yes.
The Honorable Supreme Court, while order dated 15/7/2019, modified the order, and the relevant page is page 54. The direction was issued. Page 54.
Yes.
In view of the above position, we issue the following direction. I am concerned with direction number 3. Insofar as the first respondent, namely the original petitioner before the High Court is concerned, we record the assurance of the state which was made on affidavit before the High Court and which was reiterated in the course of submission in the present proceedings that the state shall permit during the pendency of the writ proceedings the first respondent to operate the notes which are presently in operation, and in addition thereto 27 notes pending further orders before the High Court. The state shall, however, verify the exact number of notes in operation. And at page 55, the Honorable Supreme Court requested the Honorable Chief Justice to hear the matter, Your Lordship. Page 55 is the first line.
Yes.
And pursuant to the order passed by the Honorable Supreme Court, Your Lordship may kindly see page 58.
Yes.
This has been issued by the OP number 1, establishment of telemedicine project by OTED, inviting reference to the subject cited above. I am directed to say that keeping in view the direction of the Honorable Apex Court in SLP number 15315/19 and at the present request of OTED, they are requested to provide space at the respective locations and extend necessary cooperation to the 21 notes which are presently functional out of the 35 notes as reflected in the enclosed list at the facilitating establishment of the said telemedicine centers through OTED. Your Lordship may kindly see page 59. The name of the petitioners appear at CL number 19, 22 and 23. The notes which were they were the SDH Patnagar, CHC Kantabachi, CHC Sointara. These are the notes which are operational by the petitioner, Your Lordship. Now, Your Lordship may kindly see page. Identical matters were before this Honorable Court. Your Lordship may kindly see page 66.
Page
66.
66.
These petitioners, Manoj Kumar Padi, Vimal Chandra Deep and Basanti Nag, are identical entrepreneurs under the OP number 6 who had approached this Honorable Court. And this Honorable Court, you also may kindly see the starting page is page 69.
Is it batch of repetition?
Yes.
Yes.
And this Honorable Court at page 70 has reflected the order of the Honorable Supreme Court. Page 70. I am concerned with page 71.
Yes.
71 para 4. In view of the above orders, the state government is expected to permit the trust as well as the entrepreneurs to operate the notes which are presently in operation, and in addition thereto 27 notes pending further orders before the High Court. It is obvious that the above direction have to be implemented forthwith by the state government since they were issued by the Supreme Court of India in the appeals filed by the state itself. And some writ petitions were disposed of, and the two main writ petitions are at item 56 of today's list. That has to be heard as per direction of the Honorable Supreme Court. But so far as the present petitioner in item number 7 is concerned, they are not being disbursed the reimbursement fees, Your Lordship, by the state. Though as per the direction of the Honorable Supreme Court, they are working. And Your Lordship, I showed at page number 58 that they have been identified by the state, but they are not being paid the reimbursement fees, Your Lordship. They are working under the OP number 6, for which my learned senior is appearing. But the state, Your Lordship, may kindly see page 29.
What is this basic order that you are agreed by? This is order dated 22/3/2023.
My Lord.
Annexure 12 is the order you have challenged here. Or you are relying on that?
I am relying. 62. No, 62 is the order of this Honorable Court.
That you are challenging?
No.
Why have you referred this order?
Because identical persons like me, I showed in page number, the Lordship may kindly see. Page number, this is the starting of page 62. Page 60,
you have shown us.
My Lord, 66, the similarly situated entrepreneurs had approached this Honorable Court, the order I read just now. By this Honorable Court.
The first of these IAs are all disposable.
My Lord,
sir. Sit down for final hearing, sir.
My Lord.
This we are not concerned. What is the 15th July 2019 order by the Supreme Court?
That I read page 51.
Page 51.
Against the interim order passed by this Honorable Court staying the impugned order, the state had moved the Honorable Supreme Court. Page 51 is the starting.
You had filed a writ petition which you had withdrawn.
No, that was withdrawn because there were some typing mistakes, Your Lordship.
What is the number?
That number
Does
is
it come with this?
no. That is WPC number 20,508/23. Withdrawn, I have to file a better application. White order dated 1/8/23. Item 56 and this item 7 are interconnected, Your Lordship.
No order has been passed in this matter as yet.
No, this is a fresh matter.
The other matter that you are mentioning is connected.
That is item number 56, where we are the petitioners, my lord. So OTET, Orissa Trust of Technical Education and others.
Okay.
Well, that matter relates to the entire main issue. My lords, we basically brought in the concept of telemedicine within the state of Orissa in a PPP mode, my lords, with the state government, my lords. And after we continued, my lords, in pursuance of statutory notifications and my lords, public policy, they entered into an MOU with us and we continued for 7 years. Thereafter, what happened? Suddenly they are trying to change their policy and my lords, notwithstanding the fact that we have been operating for so many years, they want to change the entire policy and oust us and say that we are going in for a fresh tendering process.
Since central government.
And so under this...
No, before the earlier agreement was in force, then they have withdrawn this.
Our entire grounds are based on the concept of promissory estoppel. Second is you are in partnership with me. Okay. How can you place yourself in the exalted status of state?
Order has been passed by this court.
Mala?
In item 56.
Pending before your lordships, that the Apex Court has requested the Honorable Chief Justice, this Honorable Court, to hear the matter because of the importance of this matter.
Yeah, that is why I'm just going to. So, Mudali, are you appearing for this?
Item 56.
56 and the present one.
The present one I am appearing.
56 who is appearing because they are similar.
My launch similar.
These are exactly identical. Maybe
No, it's not identical. My lords, they are basically, my lords, we are the main, under the PPP mode, my lords, we and the state government. And my lords, with us is Biocon, my lords. All three.
These are compositions of the stakeholders may be different.
No, my lords, we are the hub. We have made nodes, they are in various villages, my lords. They operate in the panchayats and other levels, my lords. The concept of telemedicine is, my lords, a person in a village.
Understanding the nodes they provide, they are the service providers.
Service providers. And they relay this information to the hospitals, to the government hospitals as well as the private hospitals, so that a person, suppose he is afflicted with a heart attack or something, my lords, he can be immediately shifted to the nearest center, my lord, so that we can get proper treatment. This is the concept of, this has been recognized by WHO, my lords. Our project
yes.
And my lords, now
new concept is a very old concept.
Yes, my lords.
It started in 90s only.
Yes, my lords. And now, my lords, we I'll satisfy because that writ application.
What is your prayer in that 56?
56 ballots, they have to stick to their MOU. The state government cannot now suddenly withdraw.
Already, and he wants only the users fee.
Here, my lords, whether this order has been implemented or not, that the state can answer. Because they are working and the state is not paying them, my lords. That is their grievance.
We are issuing notice and both
Will you Lakshmi kindly say whether there is any contract between the petitioner and state?
In the present case, that
Yes.
is what we.
That is why your Lakshmi kindly see page 29.
Yes.
Page 29. Your relevant is page 28.
Supreme Court.
Coming to the 29.
Page 28 is 12, 12, 12. Page 28, 29, the last para. As required, collection of fees for services like electronic OPD, IPD registration with vital parameters and creation of PHR, other diagnostic services, other tests, teleconsultation, etc. to be charged as per the rates approved by the government order dated such and such, duly communicated by clause number such of the SOP. The financial mode of realization of user fees at the rate of ₹15 by OTIT and ₹25 by the entrepreneur for consultation with vital parameters and creation of PHR as has been approved. In case of patient covered under any scheme of the government, the charges will be reimbursed or be paid by the state by the government as per the provision of the scheme concerned. In case of others, the charges will be collected from patients. So the state has to pay through OTET to us. That is our submission.
And my lords, this has to be read in consonance.
It says that when you have not charged from the patients,
my lord,
only then you can get the reimbursement from the state.
The reimbursement fees has to be given by the state through OTET to us.
Okay.
My lords, and this has to be read in consonance with the orders of the apex court, which says, which my learned friend was placing, insofar as the first respondent, namely the original petitioner, that is us, before the High Court is concerned, we record the assurance, that is at page 54, we record the assurance of the state. They made an assurance before the Honorable Apex Court, which was made on affidavit before the High Court and which has been reiterated in the course of submissions
of your writ petition.
This brief.
This writ application.
All right. Just let us check.
Yes, my lords.
But does his name appear in the list of operating notes? This list
appear. Their names appear.
Page 58 is in my name.
They are the notes.
All right.
Clause 3. That the state shall permit during the pendency of the writ applications the first respondent to operate the notes which are presently in operation. In addition thereto 27 notes pending further orders before the High Court. And my lords, these payments flow out of an executive order which is under the SOP. Until 2015 they are paid, but thereafter they have stopped payment.
You are Mr. Rautri?
My lord.
Mr. Shubhadat Rautri, Learned Counsel, hearing for the petitioner. It has been stated by the petitioner.
You can say paragraph 1 of the writ petition. They have executed the agreements with the opposite party number 6 and they are submitting the bills to the opposite party number 6.
But we have shown, because Mr. Karangu has shown that your policy is very categorical and there is a communication between the Deputy Secretary to the Principal Secretary that if they do not charge from the patients for whatever reason, and there is, according to Mr. Karangu also, there is an SOP, how that is to be realized, then it is your responsibility to reimburse these fees to the user's fee.
No, that is not there.
SOP is page 25. Page 25. All the details are given in the 2015 writ petition, which is at item number 56.
All right.
Where is the order of the Supreme Court? Annexure?
Your Lordship, may kindly see page 51.
51.
Annexure 9.
We set aside the order of the High Court.
Yes, my lords.
The interim order.
The interim, the stay order, my lords, which was granted, an absolute stay was granted, that was modified to this extent.
Mr. Muduri, that what I proposed that on 18th I fixing the matter for final hearing. There is nothing factual aspects to be inquired into, because on the basis of the operation, module will decide whether they will be entitled or not. Whether you are under this present setup that you yourself is introduced, you have made yourself liable for this reimbursement or not. That is the limited issue, and their issue is somewhat different. I understand Mr. Kanungo's issues, that entire system you have overhauled, going beyond the what was the memorandum of understanding with them.
Yes.
So that is the only point of the
So far as the present writ petition is concerned, and the limited issue is whether state has any direct connection with the present petition.
State has any liability, that is the issue. Because the communication that has been shown right now, it shows that you have yourself is accepted that if the
And pursuant to advertisement, they have been selected. And they are partners with us. They just want to absolve themselves of every liability, so like we are the state. They are acting like Dr. Jekyll and Mr. Hyde.
Useless too, because bring all these facts on record. You have not filed the counter affidavit.
No, page 28, which was placed, the first page it has not been placed, only operative person has been. It is addressed to the OTET, that is opposite partner.
OTET is represented by Mr. Kanan.
No, because he has to raise the bill.
According to them, they have raised the bill, reimbursement bill.
They have raised all bills.
Look, now the petitioner is here, not the OTET. The pleadings made in paragraph
supporting him.
Pleadings made in paragraph 1 of the writ petition is that they have been selected by the opposite party number 6.
Just think, because this is the technical objections you are entitled to take. There is no difficulty in
and they have submitted to the opposite party number 6.
You have introduced a setup under the memorandum of understanding with this Mr. Kanungo's client.
Yes.
And they will set up the notes for it on behalf of the government.
Yes.
And they have set up the note.
Yes.
And they are just supervising every activities. And according to that note, this Mr. Rautri's client will be operates the notes, provide the service, and where they cannot charge the fee from the patient, that is reimbursable through the clients of Mr. Kanungo. And they have raised the bills. Their allegation in common now, you are not honoring those bills. That is the one issue. Second issue that is particularly important for Mr. Kanungo's case is that you have just resigned from your own promise. Can you do that? That's a simple issue.
That was injuncted by this Honorable Court, matter carried to Honorable Apex Court. Apex Court clarified that state can change its policy and go.
That is no, all right. You can take up. We are issuing notice. Because all residing from the promise is not judicially reviewable. But if it is that there is a sufficient change, alteration of the position has been done, investment has been made, then of course that is subject to review. These issues as in several decisions of the Supreme Court has been categorically held. Supreme Court here says the government can change policy. This is the old decision of the Supreme Court. Yes. Government can change his earlier policy. There is no issue in that.
In this matter,
Mr. Kanungo, these are qualified so many conditions. Government has changed. A change may not affect anyone, but change can affect someone who is already under this agreement. They have altered their positions, invested a lot, and they cannot go back to that position without any prejudice or damage. In that case, you are to made liable for making this payment. You can change. Nobody will be opposed that you cannot change. Policy is always subject to change. You can change it. But all the factors, you cannot just ignore it. That whatever happens, I will change my policy. So you file a short affidavit.
This matter.
The other matter you have not taken up.
56, my lords, I propose your lordship may fix up a date. We will prepare a written note as well as we will paginate the entire brief
All right, you do it by 18th.
18th, yes.
Item 7 may also be tagged along with 556.
No,
this is a different issue.
No, I'm not talking on the same date of those matters.
My lords.
Just a minute. By means of this petition, the petitioner has asked this court to direct the opposite parties, more particularly opposite party number 1 and 3, to reimburse the user fees charges to the petitioner in terms of the order dated 12/12/2012, Section 14, to the repetition, and order dated 5/7/2019, passed in civil appeal number 5532 and 5533 of 2019, Annexation 9 to the repetition, and the order passed by the Honorable Court dated 22/3/2023, passed in WPC number 32827 of 2020, WPC number 32826 of 2020, and the bench under Annexation 12 within a reasonable time. Issue notice. Since Mr. P.K. Mudoli, Learned Counsel, appears and waves notice for the opposite parties number 1, 2, 3, and 4.
Except 6. Except 6.
1, 2, 3, 4, 5, 7, and 8. No formal notice in respect of those respondents is called for. So for the respondent number 6 is concerned, Mr. M. Kanangul and Senior Counsel listed by your name, sir?
S.R. Mahanti.
S.R. Mahanti appears and waves notice, and no formal notice is called for. For the Learned Counsel for the petitioners, you have got the sufficient copies, I think. Mr. Rautri, Learned Counsel for the appellants, will supply a copy of the writ petition with all inclusions to Mr. Mohanty, Learned Counsel, appealing for the opposite party number 6. Stop. And the notice is made returnable on 18th September, right? 18th September 2023. Stop. It is expected that opposite parties number 1 to 5 and 7 to 8 shall file their counter affidavit by the next date. The opposite party number 6, if is inclined to file any statement of facts in respect to the present writ petition, they are also given liberty to file such statement. Stop. There shall be an attempt to hear the matter finally on the next date. Now, this is 56. All right.
Well, item number 4 and 56, my lords. That is the main rate application.
56.
Item 4. WPC number.
Item number 4?
No, hold on. Sub item 4. WPC number 17691 of 2015.
WPC number?
17691 of 2015.
This is according to the main.
This is the main rate application.
All right. This is a 2015 order. I think that notice has been issued.
Yes. Notice, I think pleadings are complete. My lords, not on the 18th, my lords, sir. 18th, 19th, 20th.
Let it be there because the first date after notice. So,
yeah. Yes, my lords. 18th, the first matter may be taken up, but this matter may kindly be taken up on 21st or 22nd. 56, the main rate application.
All right, you just.
But that item 56, wasn't it a single bench matter?
No, it's division.
WBC 1769.
There is a direction by the Honorable Supreme Court
For the Honorable Chief Justice to hear the matter.
No, but single bench or division bench?
Division bench. Division.
Because 17691 I find is a single bench
So
matter.
actually it was being heard by Honorable Single Judge, but you also can see page 54
Of which petition?
well, of the item number 7. The order of the Honorable Apex Court.
Oh, that is the reason I know.
And thereafter it has come up before a division bench.
Yes,
It has
yes.
submitted the matter.
Yes.
So direction is we request the Lord Chief Justice of the High Court to take up the matter before a bench presided over by his lordship so that finally to this.
Bench presided over means it can be a single bench also. It's not necessary division bench. But after that order, it has been listed before a division.
Before a division bench.
Only problem is this: the petitioner will be losing one problem. Here that doesn't have anything to grumble over. So all right, let us take in a division bench.
Your Lordship, kindly fix it up to 22nd. Because 20th, I'm just going out. Well, it's 20th, I'll be back. It is Friday. 22nd or 21st?
21st, yes.
Malas. Be privileged.
This is 6 on the matter. Just follow the March order. There is a March order. Huh? The same way. The order first one. Let the matter be listed on 21st of September. Right.
Be privileged.
Item number 8.
Your Lordship, this is a sales tax revision, Your Lordship, challenging the order of law and sales tax, Odisha sales tax tribunal, Your Lordship. It is a simple question of law, Your Lordship, but it is
1769 of 2015. You follow this order from that order, huh? There is an order of 22/3/2023. With this all, huh? Same way, we just follow the pattern. Yes, Mr. Maestri.
Your Lordship, the challenge here is that Law and Sales Tax, Odisha Sales Tax Tribunal has wrongly interpreted an entry of Odisha Sales Tax Act, Your Lordship. Your Lordship, my question of law is at page 14, Your Lordship, page 14 of the brief.
Whether there is any caveat?
No, Your Lordship, the opposite party has already appeared, Your Lordship. My Law and Seniors has appeared. So the question here has already been interpreted by this Honorable Court. My Lord and friend, the additional standing counsel, Mr. Padi, on the last occasion has mentioned that it has been covered, squarely covered by the judgment of this Honorable Court in State of Odisha versus Gitasri. But Your Lordship, the interpretation here is covered. And in that case, what happened, Your Lordship, background in that case, that was in Odisha Entry Tax Act, Your Lordship. In Odisha Entry Tax Act, cattle feed was taxable, was a civil good.
There was a brand is the
exactly choker, government and cattle feed, and the department has said in those cases interpreted that since chewing and choker have been sold as cattle feed, hence it is a scheduled good and cattle feed. And this Honorable Court has decided at paragraph 18 and 19 that chewing and choker cannot itself as a cattle feed, and since cattle feed is taxable, it is one of the ingredients and it cannot be as a scheduled good, Your Lordship. So, in paragraph 18, this Honorable Court has said that you cannot tax chewing or choker as taxable as cattle feed. And here, this case is under Odisha Sales Tax Act, and the goods, input goods is brand. Your Lordship, this interpretation is here, and this has been wrongly interpreted by Odisha Sales Tax Tribunal that brand has been sold as cattle feed, and since it has been sold as cattle feed, and since cattle feed is exempted, so brand is exempted. Now, Your Lordship, the entries of the, Your Lordship, may kindly turn to page 6 of my page, the entry of Odisha Sales Tax Act, Your Lordship, I have quoted. This is the period 99-2000, Your Lordship. The period is very important here. Your Lordship, the tax bill is what has been interpreted by Law and Odisha Sales Tax Tribunal, 30D. Can I place, Your Lordship?
Yes.
Your Lordship, at page 6 of my brief. RATHO B is that sale of feed or fodder such as husk, straw, hay, grass, oil cake, and manufactured mixed balanced feed for cattle, poultry, and pig. So this manufactured mixed balanced feed for cattle is exempted. Your Lordship, there is no issue. Now, Your Lordship, so far as the brand, Your Lordship, the second here, from the position from 1/5/1976 to 8/2/99, the entry was entry number 2, brand, it sold for images cattle feed. So that is
No tax.
no tax. Now you will see the next phase, the position from 1/7/90 to 8/2/90. Sorry, you will see that is still 90. 31/6/90. That has been wrongly here. So the position from 1/7/90 to 8/2/99, one except when sold as cattle feed. This was the previous.
No, for any other purpose, if brand is sold, that will be 4% taxable. That's what.
That is prior to 1899.
Yes.
So 1899, number 15 was the brand except when sold as cattle feed. So it is taxable, but it is when sold as cattle feed, that is not taxable, that is exempted. So on 9/99, Your Lordship, that has been amended. Except when sold as cattle feed has been omitted. So simple brand is taxable at the rate of 4%. From 9/2/99, it is applicable. And let's see, this period is 99.
Is that amendment? Can we just see it for a moment? After this 9/2/1999, the amendment carried on 9/2/1999. What is that amendment part?
That amendment, let's see, actually
it is incorporated in the rate chart.
Rate chart.
There are two schedules in the attached to the statute. List A is the list of exempted goods. List C is the list of taxable goods.
I know.
So list A contains these 30 dealers.
How it formed after the amendment?
There are two separate entries in two separate schedules that existed simultaneously. When the exempted schedule contained 30D, which exempted the feed and fodder for animals, different types of animals, which included horse, hay, grass, etc. Now that is an inclusive definition.
That is in the petition.
Yes, sir. And so far as simultaneously are there. One is exempted 30D, that is cattle feed, and your ban is taxable at the rate of 4%. So, except when sold as cattle feed, that was there. That's recommended. So my respectful submission to your Lordship is that, as per that judgment of Gita say, brand cannot be except said as cattle feed. Number one. And number two is that when the entry is very clear for the interim period, that is taxable at the rate of 4%. And that except so when sold as cattle feed has been omitted. So my respectful submission, it is taxable at the rate of 4%. There cannot be interpretation. Your Lordship, since it is a taxing entry. Subsequently, what happened? From 1/2001, APM has been amended, which has been interpreted by Law and Orissa Sales Tax Tribunal, but it has been omitted. The ban has been omitted from the taxable list. Why it has been omitted? Because it has been entered in the purchase tax list. So, purchase tax list, it has been omitted. So, that is in my respectful submission before your Lordship is that interpretation, your Lordship, one is ban is not cattle feed. It cannot be termed as cattle feed. It may be one of the ingredient out of 16 ingredients in as per that judgment, your Lordship, that interpretation. And second, as per Orissa Sales Tax Act, for the interim period 99-2000, that is 1/4/99 to 31st March 2000, your Lordship, the entry was very clear and that ban is there, and so it cannot be interpreted otherwise. That is my respectful submission before your Lordship. Now, your Lordship may kindly turn to the interim order, how the Law and Orissa Sales Tax Tribunal was interpreted. The interpretation of law, your Lordship, at page 30, running page 30, internal page 3, your Lordship, paragraph 6.
Your Lordship, we heard so and so, Your Lordship. It is seen in the instant case, the applicant is a flour mill who mills wheat, produces atta, maida, suji is the main product, and also often choker, that is bran husk as byproduct. During the 11th period, the applicant effected sale of his finished product and byproduct and effected the same in the return. When tax was paid on the finished product, the byproduct choker being exempted under entry 30 of the tax-free schedule. No tax was paid on the turnover of sale of choker, bran husk. The assessing officer, without specifying any reason, simply included the turnover of sale withdrawn in the taxable turnover determined by him and subjected it to tax, along with other additions on account of non-furnishing declaration Form 1D. In the first appeal, the appellate authority deleted the addition on account of non-furnishing of form and submission of form by the appellant before him. However, has upheld the inclusion of turnover of wheat bran in the TTO on the ground that if sold for use as cattle feed, having been deleted from entry 15 in the taxable schedule by notification number 8699 with effect from 8 to 99. Wheat bran is accessible to tax at the relevant period. The specific case of the appellant is that the sale of wheat bran husk, which is essentially known in common parlance and common commercial parlance as cattle feed, and as such same is exempt under entry 30D of list A. In support of his claim that wheat bran is essentially a cattle feed and the appellant relies on the decision of Patna High Court so and so, wherein after going through different judgment of the various court, essentially a cattle feed and mere use by some other person would not make a difference. The other ground challenge appellant is inclusion of commodity in the tax would not itself take away the exemption, and it will still continue to be exempt until the exemption entry itself is omitted and amended suitably. The appellant case is wheat bran being exempt under 30D as cattle feed would therefore continue to be exempted, notwithstanding amendment of taxable list under entry 15. In support of this proposition of the law, Patna High Court in Mahabir flour mill, while dealing with an identical situation in the court as the unless exemption notification itself is withdrawn, it will continue to have force irrespective of the fact that a rate has been prescribed for commodity in question. The dealer submitted that it is also a case that there can be no tax by implication, which is settled principle of interpretation of statute. The appellant also relies on the proposition of Patna High Court so and and submitted. Your Lordship, all this may not be applicable. Your Lordship may kindly, the further case of the appellant is that legislature never intended to take out the benefit of exemption in so far as it delay wheat bran or husk. The appellant to substantiate his case refers to the SRO number 151 2001 dated 31st/3/2001. It is subsequent to the period in which the new entry 15A rice bran has been inserted with effect from 1/4/2001. The appellant submits that removal of bran under entry 15 altogether, and then the subsequent insertion of new entry 15(1) itself suggests the amendment of the entry is clarificatory in nature and was made to dispel ambiguity, if any, that had crept in subsequent to the amendment 8 to 99. To further strengthen his claim, the appellant, which was so and so 1/4/2000 bran other than rice bran, the appellant submits that the amendment as given above clearly indicates that intention of the legislature. Your Lordship, the intention has been taken so far as the 2001 amendment. Your Lordship may kindly next page 6 to 7 lines below. In any case, of the matter in the present case, the fact remains that the appellant has sold wheat bran only as cattle feed, which is evident from entries in his sale register and sale memo, lastly, Odisha sales tax memo. So the interpretation here is that since the bran has been sold as cattle feed, it is exempted under entry 30D. Your Lordship, my respectful submission before Your Lordship is that it is squarely covered. This interpretation is squarely covered by that Gitasi judgment, where it has been categorically made by this honorable court that bran or choker or chimney cannot be itself turned as cattle feed, Your Lordship. It is one of the submissions for that reason, for that in view of that judgment of this honorable court, section of the entry 30D is not accepted because it cannot be termed as cattle feed. So the second point of submission in this case is that after the period, there is a particular entry, that bran is taxable, entry is there. So since it is a taxable entry, since it is a taxation entry, it has to be strictly interpreted. That cannot be any interpretation, otherwise, Your Lordship. Hence, it is taxable, and the Lawrence Sales Tax Tribunal has wrongly interpreted that and deleted that issue, Your Lordship.
All right. That's all.
Good. Yes. That's it.
So far as we are hearing for disposal. Yes, Lordship. Yes, sir. I'm aware. That's it. So far as the particular entry that whether the fact.
And sorry, Your Lordship, only one judgment of another Supreme Court. So far as the taxable entry is concerned, so far as the exemption notification, Your Lordship may kindly, I'm sorry, Your Lordship may kindly turn to page 19. Your Lordship knows very well, you well aware about the law, Your Lordship. Only part it is the latest judgment at paragraph 19. Many judgments have been cited, that many judgments have been recognized by the Honorable Supreme Court. Your Lordship, how the exemption notification, how the it has to be strictly interpreted. Your Lordship, for that case, I have sought judgment, but I am placing this judgment in this case. Also, it is my opportunity tomorrow also, I will cite this judgment for that case also. All right. Your Lordship.
There's a old law, nothing new in that.
Your Lordship. That is why, so far as the judgment of this Honorable Court in Gitasi's case, my only submission is that rather helps my case than that of the state lordship. Because in that case, what was for consideration before the Honorable Court is whether entry 66 in the Entry Tax Act, which was cattle feed, for the purpose of interpreting section 26, which is an obligation on part of the manufacturer to collect tax on its finished products, can be attracted, say, in case of a dal mill, lordship, which produces or whose byproduct is chunni. Specifically, chunni was their case. Chunni can be said to be cattle feed vis-a-vis entry 66 of the Act, and therefore the obligation can be cast upon a manufacturer to collect tax under section 26 of the Act. Yes. While interpreting this, examining the entry 20, section 26 of the Act, this Honorable Court has come to hold that chunni is not a finished product of the dal mills, and it is merely a byproduct of the dal mill. Besides that, on the basis of a tender notice that was placed before the Honorable Court of the Odisha Milk Producers Cooperative, the Honorable Court came to this whole that observed that chunni by itself is not a cattle feed, and it can be a cattle feed if it is mixed with the other ingredients there. There is so far the cattle feed is concerned, the primary thing is to be understood is cattle feed of two kinds. The original products, like the quick bran in my case, hay, in several other
problem
feed products.
Is I understand that a group of names have been clubbed together in the previous provision when they has brought under the umbrella of this cattle feed.
That's it.
But the brand has been completely excluded first for treating it differently. It says, provision is very clear, the brand for the cattle feed, no tax.
No tax.
Right. But brand for the other purposes.
In the taxing entry, two entries existed simultaneously. One under the exemption list, the other under the taxing list.
Yes.
The one under the exemption list, so far as I am concerned, yes, I am coming under entry 30D, which mentions feed and fodder. Feed and fodder such as husk, straw, hay, grass, and manufactured, mixed, balanced,
feed for cattle, poultry, feed. And my case is, I am not specifically selling cattle feed. My product is a feed. Worldwide recognized wheat bran is a feed for is an animal feed, and by itself it can be fed up to a certain percentage of a diet of an animal. There are various recommendations that I have brought with me. Plus, of different international journals of veterinary nutrition, where it says that wheat bran is recognized. Even in India, I have found out that several brands of wheat bran as such are being sold as animal feed. So the very fact that in the taxing schedule, bran excluding when sold as cattle feed is mentioned, that presupposes that bran can be used as cattle feed. Otherwise, that would not have been there in the taxing schedule.
There, Mr. Mishra is also not.
Gitasi's case is concerned.
According to him, that was up to a certain
point. That's it. That I will counter.
It has been
that I will counter. The very submission that Gitasi is following up on, because on the ground that Gitasi has said chunni is not cattle feed. That is why wheat bran is not cattle feed. If that he concedes to that wheat bran is a cattle feed, thereafter my argument would be, Lordship, as my friend has admitted, and it is a matter of on record, that this amendment, Lordship, that was there,
yes,
to the taxing entry, Lordship, it came in from 9th of February 1999. We are concerned here for 99-2000, Lordship. 1st April 99 to 31st March 2000. So this entry came in from 2nd of September 9th of February 99, and it continued as such till 31st March 2001, Lordship. Thereafter again, Lordship, amendment to the schedule was made where only rice bran was kept out from the exemption. Thereafter, only rice bran was kept out for exemption. Again, wheat bran, if we look at the schedule, therefore my argument is this legislature never intended to keep wheat bran out of the purview of exemption, and besides that, Gitasi elaborately, this Honorable Court has discussed how an entry in the exemption schedule be interpreted differently from a taxing schedule. In interpretation of taxing entries, taxing statute, when it comes to taxing a subject, the interpretation has to be very strictly, the provision has to be very strictly interpreted. But when it comes to interpreting an exemption notification, it has to be given a liberal interpretation, keeping in mind the benefit that will pass, to whom it passes. So I am a miller. So if I collect tax on wheat bran, the ultimate consumer.
Not only the miller, you are also the seller.
I am also a seller. I am the miller and the seller. So the obligation cast upon me to collect tax is the incidence of tax is not me or Lordship. I collect the tax from the buyer, who happens to be an end user and a farmer. That is why keeping the benefit to for the end user farmers.
No, the question boils down to a very certain level now. After the amendment has been carried out, the question has been taken away. Whether there is any scope of a liberal interpretation.
That's my
the question Mr. Mishra is raising.
My submission
went wrong because they have tried to give on the basis of misinterpreting the judgment. Or the misunderstanding the judgment in the Gitasi Industries.
The Gitasi was not at that time not on the
is not on this.
Even subsequent to Gitasi, in another judgment that of this Honorable Court, this exemption Lordship even was carried up to repeal of the Odisha Sales Tax Act under the Value Added Tax Act, where similar entries, exemption entries, were brought in under the Odisha VAT Act, where feed and fodder for animal consumption were provided under the exemption list, which specifically also had, amongst other things,
wheat bran was mentioned over there also. So wheat bran, my humble submission is never intended to be taken out of the exemption list regarding the farmer, animal poultry or cattle farmer from the benefit of the exemption.
This is a page 33. Why I'm telling you? Maybe there is no reference to this. You are absolutely right. It is from the 5th line, actually, page 33.
33. Page 33 of the
this paper with the petition. Moreover, in the present case, the state does not dispute that wheat bran is essentially a cattle feed in common parlance. Hence, mere amendment in the list of rates prescribed for taxing goods without withdrawing or amending entry notified under Section 6 cannot take away the benefits of exemption in respect of wheat bran. That is the issue. Because
the 30D, that is what I am saying. Yes. 30D, I will place once again, my Lord, friend has extracted the 30D in 6, 30D says sale of feed and fodder such as husk, straw, hay, grass, oil cake, and manufactured mixed balanced feed for cattle, poultry, and pig, etc. That's it. My humble submission is this is an illustrative, this is not an exhaustive list. This is an illustrative list, and this also would include wheat bran. I'm only concerned with wheat bran, not rice bran. I'm concerned with wheat bran. So therefore,
the issue is the same. Yes, the exemption list, and he has preferred a decision. As Judean principles will apply or not.
That's it.
If there is no ordering route, so bran must be there, must be at 30D, because hay, such as horse, straw, hay, grass, everything is there. So bran might have been there. Since the EPTS, the only use is the cattle feed, what my Lord Senior submitted. For that reason, it is in the taxable list, and in 1999, it was exempted even shown as cattle feed. Because there are many uses. Than 1 year. Only for little more than 1 year. That will consider. That is the fact.
This is the and why would just one product used for the two other purposes? There may be the multiple uses. That's it. But the problem is that we are collecting the tax. Can you ask that what is the purpose of the purchase?
My submission
the exemption is use based. Any meaning that
why is exempted? How is exempted has been done, 30D. Sale of fodder such as so and so. And capital means the goods, this in this case, what this honorable court has said. That 16 ingredients, after mixing of 16 ingredients, category is there. And that category is exempted. Not only the ingredients are exempted, but that ingredient, horse, straw, hay, grass, these are exempted. And after making 16 ingredient mixture,
balanced feed.
Exactly. For that is a manufactured mixed balanced feed for cattle. So after mixing these 16 ingredients, we became a cattle feed and it is exempted. So for that reason, the intention of this feature that the brand was exempted till 1999, it was sold that cattle feed. And we not sold, it is taxable at the rate of proportion. This except when sold as cattle feed has been omitted from 1919. So my submission
This 15A exemption was earlier?
No, the taxable at 15. Taxable at 15, and 15 was at 37. 37 that is 15 prior to amendment plus 15 after emission, after deletion.
Yes.
So for the clear, this is very clear, and what is taxable at the rate of 4%? Cannot, Even if the taxi judgment, also I am submitting the interpretation. Even after that interpretation is not required, may not be required for the input period.
Right.
It is a taxing period in the taxing statute.
Now from that point you start again.
Lordship, so for 30, again going back to 30B, Lordship, as my lord pointed out just, entry in the taxing schedule, can it make it redundant, Lordship? 30D. 30D is an illustrative list, Lordship noticed.
Yes.
In 30D, sale of food folders such as itself indicates that it is an illustrative list. And it is not an exhaustive list. And such as so and so, Lordship. And my case is wheat bran always is a feed and fodder for the animals, not just cattle. And it is for all kinds of animals, the poultry and pig. It's widely used as such worldwide and recognized as such, Lordship. And if we look at the taxing entry, Lordship, as it was before the amendment, Lordship, on this, which is just contained below there, Lordship. Wheat bran, the bran, Lordship, it was contained bran otherwise than when sold as cattle feed. That itself presupposes that bran was capable of being as cattle feed, at least as cattle feed, not other, maybe not other animal feeds, but it is a fact that it is used as all kinds of animal feeds. Therefore, my submission is without appropriately modifying the exemption entry as contained in 30D, can an amendment in a taxing schedule automatically obliterate the benefits that accrues to a person from the on an exemption list? So it cannot be done. So, as has been held in that judgment that I have decided, tribunal has quoted there, that was specifically on that point. In Mahabir flour mills case, 65 STC. And
they were all quotas, Gitosri industry.
Gitosri, was on a different aspect altogether. And the general observation to that, and I will answer to that also, that is the Honorable Court, I have collected a came across National Dairy Development Board's Anand's literature, where compound cattle feed is manufactured there, Lordship. It has, Lordship may just have a look at it. Before indulging into the manufacture, the objective was recorded there in the introduction of the next page of the.
This for the first time you are introducing this paper.
This is for it was not necessary because in the tribunal, on the basis of my written note of submission and the judgment cited, has come to hold that entry 30D applies to me. And on fact also, another aspect I will argue is where this section 24, which the state has invoked to approach my lords, is limited to questions of laws.
Difficulty. Just see. This also talks about the compound cattle
feed. There are two.
Also the balance supplement for increasing the milk.
There are two different.
The composition would be of the multiple grains. Grains and shoots.
So in lots of introduction,
Mr. doesn't have objection. There will be the common trade parlance test would be followed, that what is the written as the cattle feed will come under the cattle feed.
Yes, sir. The always will come under cattle feed. So our limited
is he has made a very unique submission because he has intricately analyzed this entry. Bran is not exempted. No, the wheat bran and bran is not totally exempted. Earlier bran was there, but that has been amended. There is no dispute about that. He says the bran is an independent component. As a cattle, it may be used as cattle feed, may not be used as a cattle feed, but exemption has been not granted to that particular component. But bran can be used as for the preparation of the balanced food. But this entity of the brand will be lost. Only this exemption will be available in this balanced compound food. That will be there. That is his argument. So as independent component.
As independent component.
Brand doesn't come under the exemption list. That is the crux of his submission.
His submission is 30B, like in the illustration, let's see.
Yes.
Does not mentions hay and grass, etc., but does not mention brand. It says such as. My submission is such as may include many other things which would constitute animal food.
That is the fundamentally I was going to convince this court whether the principle of adjudant generis can be applied in the state statute.
Again, Lassie, we are interpreting 30D, Lassie, as observed in the.
No, my question is very categorical. In the state statute, whether we can apply the doctrine of adjudant generis. Can it be applied?
In an exemption,
what you are primarily arguing, they apply that principle.
That's it.
These are the things, and similar other things also.
That's it.
Can that be applied?
Yes, it can be applied when it comes
any decision.
That's it.
Most of the decisions are
in Gita Sri. That's it. Going back to Gita Sri again.
From Gita Sri.
That's it.
On High Court decision,
that's it. Paragraph 11 onwards, that's it. I will raise before Lordships. Gita Sri from paragraph 11 onwards.
Gita Sri, according to a glance that I have given, that will support Mr. Mistress subject.
Not a category. That's a revenue stand. Whenever in Gita Sri Lassi, revenue's argument has been turned over with head Lassi by the Honorable High Court. Review in that case say Chunni is a cattle thief. That's it. And in
para 18 of Gita Sri.
That's it. That was the argument. And based on looking at certain exemption provisions and the citations made before cited certain judgments. Normally, looking at the argument of the state, say that this may be true when interpreting an exemption notification. But when it comes to taxing a subject, the interpretation has to be strictly the so allow me to place from paragraph 11. That's it.
But the paragraph 19 is the formulation of the law.
That's it. That the Honorable Court has referred to strict interpretation of the statute when it comes to a taxing entry Lordship. Indian Aluminium Company Limited and Union of India Lordship. There, the Honorable Court was justifying their view, referring to this Indian Aluminium's case, stating that the argument of the state may be correct when it comes to an exemption schedule, but when it comes to a taxing statute, interpretation of taxing entry, then it has to be strictly interpreted. Because they are interpreting section 26, which was sought to be invoked to bring in entry 66 of the first schedule of the Entry Tax Act, applying that the state wanted to say that Chunni is a cattle feed and therefore there the entry was cattle feed, not animal feed like 30 dealers, cattle feed, and therefore it can be manufacturer to collect tax. This was negative by this Honorable Court. While doing so, this Honorable Court referred to various judgments, which a few of which had been followed by the one of the benches of the Orissa Tribunal, which were in with reference to exemption schedules. This Honorable Court in paragraph 13, it is, I've mentioned, if I may place it, it is one thing to say that a certain product was exempted for the purpose of taxation by virtue of interpretation of an exemption notification. It is another to say that it is amenable to tax by bringing it within the ambit of another product shown in the schedule of ETR, and therefore bringing it within the fold of taxation. The approach of both cannot be the same. The following passage in Principle of Statutory Interpretation by Justice G.P. Singh, 13th edition, so and so, Lordship has quoted, the general rule of strict interpretation of exemption. There can, however, be no doubt that exemption made with a benevolent object, example, to encourage increased production or to give incentive to cooperative movement, or for the purpose of development of urban or rural areas for public good, have to be liberally construed. The Tata Oil Mills case has been referred to, where the exemption was allowed for use of indigenous rice bran oil in manufacture of soap. The question was whether it would be available even if the soap was made of rice bran fatty acid derived from the rice bran oil. It was observed in that context as under. The requirement is that of the soap manufacture should be prescribed extent be from rice bran oil as contrasted with the other type of oil. The contrast is not between the use of rice bran oil as opposed to rice bran fatty acid oil, acetic or hydrogenated rice bran oil. The contrast is between the use of rice bran oil as opposed to other oils. That is ordinary meaning of the word used. These words may be construed literally, but should be given their fullest amplitude and interpreted in the context of process of soap manufacture. There are no words. There were no words in the notification to restrict it solely to cases where rice bran oil is directly used in the factory claiming exemption, and so to exclude cases where soap is made by using rice bran fatty acid derived from the rice bran oil. The whole purpose of the object of notification is to encourage utilization of rice bran oil in the process of manufacture of soap in preference to various other kinds of oils, mainly edible oils, used in such manufacture, and this should not be defeated by an unduly narrow interpretation of the language of the notification, even when it is clear that rice bran oil can be used for manufacture of soap only after the conversion into fatty acid or hydrogenated oil. Thereafter, the Sun Exports case has been made. There itself, Lordship would find this term, the compound feed. That is the NDDB's literature that I handed over last year. Yes. Animal feed, including compound livestock feed. The word including, therefore, permits a wider and liberal interpretation of the term animal feed. Lordship, my humble submission is, therefore, this Honorable Court distinguished these judgments that were the tribunal has referred to in those cases, saying that those were the interpretation were dealing with exemption notification.
What is the para 15? What is the para 15? Meaning of this para 15?
Para 15.
I'm just identifying two parts of it.
Lordship.
That the exemption notification read.
Lordship.
Right. 10 animal feed, including
para 15.
Yes, para 15 of the judgment, Gitosri.
Lordship.
Including, just now you have read it.
Lordship.
Including compound livestock feed.
Lordship.
So the entity, the livestock feed, is included in the definition of
animal feed
also,
including compound feed. Lordship,
compound livestock feed.
The distinction that I was trying to show through NDDB's literature, Lordship, animal feed, anything like in another Odisha High Court case, was placed before this. Anything that commonly fed to an animal is an animal feed, but a compound feed is a feed which is manufactured, taking into several components of keeping in mind the nutritional values that an animal requires. They are manufactured products.
Yes.
But animal feeds as such, whatever we commonly feed an animal would constitute an animal feed. So not necessarily.
The problem is that I think whether a particular product is a compound livestock feed or not, only the test is the common test.
My case is I'm not on compound animal feed. My case is
a gram, the component is an independent.
I am individual feed. Like just for a second, read the NDDB's introduction.
The problem is that in the text statute, it is my personal view, bringing the external literature into the text is a very risky game.
No, just for the, this is only for the sake of distinction between what they have observed. Why they need to manufacture the compound cattle feed that they have only provided. It is maybe their personal opinion, but they have given a general scenario.
Yes.
In the introduction, low quality forages forms the bulk of the basal diet of ruminant in India. But in addition, farmers use feed their animals one or two locally available concentrate ingredients. Concentrate wheat bran is one of the concentrate ingredients. There are three kinds of concentrate ingredients. One of such is wheat bran. Yes. So, depending upon the level of milk production, unmindful of animal requirement, this type of diet is not always
this is absolutely all right.
Right.
Because we know, suppose that the wheat bran is a animal feed.
It feed itself, in many places.
The problem is that whether that has been exempted from the tax or not. It's a separate aspect and component.
That's it. I understand.
Agree on that. That in the feed. No doubt about it. He raised the question whether that feed is included in the exemption list or not by name. No. Answer is no. You also say. You say the similar other product, and we have to.
Yes. If you say such as, it will also include
because this as judem generis. Whether that will apply.
Yes.
You can kindly find a comment to and give only the judgment that as judem generis principle applied in this.
I will attitude to the type of
understanding. That should not be because it creates a lot of problems.
Yes, I will try to find out. All these interpretations could have been possible if that amendment 1999 amendment
that has been taken away. Yes.
So after that, in another thing that also like my senior knowledge training was submitting, I could not get the judgment in Reliance in the industry space, like in Reliance traders case. In Supreme Court, there was a question whether insertion of a taxing entry can automatically take away the exemption that was there. It was answered in negative, and I could not. It went from the Patna High Court last.
No, that can be happen also in a tax situation. That can also happen.
Yes.
When the policy and the purposes is determined, the same product can be also in the exemption list and can also be the price schedule.
This was for one year, 2 months or something like that. So he came back, and not just that. After in the repeal of this act, it continued under the VAT Act also as a special entry. There also in the such as that the description that included wheat bran. So
My submission is government never intended to keep Hooden out of the exemption. That's it. There's another judgment where this honorable court in March held in interpreting that exemption entry that it is only necessary to be sold wheat bran if it is sold. It is not necessary that the person who has bought it has put it to use as a cattle feed or animal feed. He can put it to any use. Still, the exemption will continue. That is what this honorable court in March.
That is the reason they have amended that.
1990. This was March 2023. Let's say.
We have to see the perspective.
Yes. That's it.
So, are you coming back at 2?
Can it be put to some time to answer the
तुझे मैटर अच्छी क्या तुझे मैटर अच्छा क्या
Yes, I am there in Tuesday.
Your Lordship, it will be taken away 2, I think.
Your Lordship.
So, all right, if you just want to take some time for that,
I think
my view, tentative view, I am telling you.
That's why I
the state.
I need a little time to, so this matter,
next Monday.
Little more time.
More time.
Little more time.
Forget. Then you are taking the risk.
No, that's it. Not on Monday, but a little bit more time.
Give us a date, then let us see.
Yes,
That I keep this together.
Can it be on 11th?
All right. Third, Mr. Learned Counsel appearing for the revision petitioner and part for continuation of hearing is the matter of 11th September 2023. So, Mr. A. Mohanty, no?
Right, yes.
A. Mohanty, Learned Counsel, was appeared for the respondent and made his submission. So, Mr. Mohanty, you address a question that has been put by this court, whether the principle of res judicata generis in interpreting the state statute can be applied or not. Well, if can be applied, we can go anyway.
Less.
Can I take a liberty to, for a while, to disturb my lords, man?
Yes.
But I was trying to make a mention in the first hour, one eminently urgent matter, where the student in National Law University of Odisha, locomotor disability, has been beaten by stray dogs at least 7 times in a month, running his life risk, my lord.
And what all these 7 months the university administration was doing?
1 month, my lord. One
month also.
1 month, 7 times.
The behavior of the state dog is that they do not come together within a very short time.
Right, but they have been writing CMC to take steps in terms of their guideline, my lord. Okay. CMC once came. In fact, there was some opposition from some of the group of students, as a result of which CMC could not take steps. That is how we have been constrained.
What do you want now?
But I have come
because this statement that you have made,
right, my lord,
that the same situation may recur in.
Well, they say that if they get direction from
who says the Vice Chancellor,
municipality, my lord.
What Vice Chancellor says.
That is the Vice Chancellor, not an instruction.
Municipality is an outside agency.
Right,
enter into the university.
Vice Chancellor cannot remove them, my lord. It is only municipality.
Whether Vice Chancellor has intention to remove them.
Yes, my lord. Yes.
No, he or she has surrendered to the.
She has only approached, my lord. She has only approached, my lord. Otherwise, I would not have problem.
Let us see. Copy of the standing council.
Right, my lord. I am sorry that I am disturbing your lordship for this morning. I'll serve it, my lord. Grateful.
Just take the memo and notice special list. Yes.
So I may be pardoned. Item 62 of your lordship's board is a criminal appeal. Well, in the last order, the appellants were asked to remain present in court. Both of them have remained present, but I have entered appearance on behalf of both the appellants. It was also directed that the registry may appoint someone from the Odisha High Court Legal Services. That effect, both of them are present.
Anyone has been engaged as for the arguing for the appellants?
Yes, Lords. We have been engaged. Lords.
You have been.
We have filed fresh for collector also.
No, you are ready.
Yes, my Lords. Your Lord. Should we fix up any date for hearing?
No,
we have been
take up the matter.
Today, my Lords.
Let us wait and see.
No, so only problem the paper book has not been supplied to us. If your Lordship may grant us 1 or 2 days time.
62 paper book is there. I think paper book is ready.
There's two sets of paper books, first line. Mr. Panda,
My Lords.
are you appearing for, there's only one appellant or more?
No, there are 2 appellants.
You're appealing for both?
My Lords.
So collect the paper book.
My Lords, I'll collect it in course of the day.
There it is. Let it come on sometime in 12th of September. 12th of September. At least on 12th of September. Meanwhile, when it, Mr. Sridhar Panda, counsel, is appearing for both the appellants, shall collect the paper book stuff. On the next date, there shall not be any accommodation. May not be any accommodation. Absolutely. Okay. The appellants who have appeared in person before us in terms of our order dated
4/7/2023, my Lords.
4/7/2023. The appellants are? Yes. The line all right. He'll continue. Will not
I'll file their Aadhaar cards, my Lords. For their present personally, I'll file their Aadhaar card.
To the court master, and he will just release them. You just only check up the other cards. Okay. All right. One paper book. There is a 2 paper books. Solid.
I'm obliged for that.
Hello.
I'd like to mention, my lords, I'm extremely sorry, my lords, item number 2, my lords, instead of Lordship directed opposite party number respond number 9. Lords, I verified it is not 9, it is respond number 4.
The direction is given to the respond number 4 to withdraw the environment clearance. That has to be
instead of 9, it may be given the instruction. The
impugned order.
NGT.
Yes. Lordship was directed.
Lordship was directed respond number 9. That is to be respond number 4.
Okay. So the order I will just necessary amendment I will make. Let's only paper.
Respond number 4 in terms of para 21. There is a para 20. Para 20 of the order.
4 is state level environment.
That, my lords.
They have been directed to withdraw the EC.
All right.
Page 224 of the appeal has been para 20. I'm good. Thanks.
20? No. All right.
Yes. Item number 23.
Just a minute. What is the matter?
We just wanted to mention item 25. It looks unlikely that this matter will be able to be taken up, and this matter will also take some time. I was only requesting Millers at my lord's pleasure and convenience, if that any date can be fixed, Millers will come back on that date.
All right. So the matter will take up, will fix the date.
Any date and then.
Which matter?
Item number 25. It's a tagged matter, Millers.
Okay.
Readings are complete. And if my lords may permit us to be taken at 2 o'clock.
All right, let us see.
Here, please.
Item number 23. My previous house.
Yes.
But so last occasion, yes, I have brought to my lord's notice certain legal preparation periods in this case. Yes. You also have probably noted down 3 or 4 preparation periods.
I have added 2 more, and today also I have prepared the 18 brief note below. From that, your lordship will find I have around 6 legal professions for us. If my lord's kind permission, if your lordship permit me, I can place only the legal profession for us. Yes, I am giving copy to my lord's class. First legal profession will be page number 1, my lords. Yes. While considering statutory definition of the expression, entry of goods in section 2B, local areas in section 2F, importer in section 2E, and expression used as entry of on entry of foreign section P1 and P2, and in explanation, the taxable event occurs at the point of first entry of scheduled goods in the state of Orissa. Therefore, the value of goods at the point of its first entry shall be measure of taxation, and not subsequent or successive entry into various local areas in course of its movement in the state till the goods reach the ultimate destination of the buyer or recipient of goods belongs. The first legal provision was. Second was, ownership of goods is immaterial for taxation under the VAT Act in view of provision of section 3(2) of the VAT Act. Therefore, sale invoice or sale bill or stock transfer invoice or refinery transfer invoice makes no tangible difference. Thus, contemplation order provided to section 2J for creating a dichotomy between the two and providing to levy tax on open market price of similar goods in case of goods obtained or acquired other by way of purchase is clearly ruled out by virtue of the charging provision made under section 3 of the VAT Act. The second clause. Third is, section 2J cannot have overriding effect over charging provision made under section 3 and shall remain to be subservient and into it and not otherwise. Therefore, the claim of the revenue justifying provided to section 2J as measure of tax runs contrary to section 3 and the ultra vires. Clause 4. Provided to section 2J, if hypothetically allowed to be considered as measure of tax, the expression used in section 2J shall be the value of price at which the scheduled goods of like kind or quality is sold or capable of being sold in the open market, clearly transgresses the sanitary constitutional legislative field envisaged under entry 52 list to 7th schedule of Constitution of India. Yes. Fifth clause. Despite of power being available under section 37(1) and 37(2) of the VAT Act to frame rules providing for statutory mechanism to determine purchase value in consonance with section 3, paragraph 52 list to 7th schedule Constitution, neither the existing rule 17 contains any such provision nor any rule is framed to determine purchase value. In both contingencies, either when the goods are brought to the state on the strength of sale invoice or bill or stock transfer invoice concerning situations falling under other than by of purchase. Thus, for want of statutory provision, providing for measure of tax, the improved provision under section 2J is not workable. Last clause. In absence of rule providing for statutory mechanism for determination of purchase value, particularly where goods are obtained or acquired other than by a purchase, provided to section 2J of the VAT Act confers unlimited and unpenalized power upon the taxing authorities to make wide determination of purchase value, which is illegal and unconstitutional, and the improved provision liable to struck down. I rely upon the state of Kerala versus Lavender Chemicals branch, 99 Supreme Court. Yes, the other day I have already brought your lordship's notice for us various provisions connected to this matter was. And now, yes, with my lord's permission, lords, yes, I will take my lord's attention to certain judgments, lords. Yes, I have given a compilation of judgments. To start with, I will take my lord's attention, lords, to the memo containing this earlier one. Yes, you have given. All right. Yes. The first judgment, lords, which still holds the field, that is the case of lords, honorable apex judgment in the case of State of Karnataka versus Hansa Corporation. I will state you not take my lords attend the operative court judgment. Paragraph 38, that is at page lords 13. Running page 13 lords. Para 38.
That's it's direct line point blocks. Two minor subsidiary points were sought to be made 10%. Yes, minors by Mr. H.T. Desai, and a brief mention of them would be in order. It was urged that there is no certain amount of vagueness in section 3 in as much as, though no light is thrown by the words of the section or the other provisions of the Act on the question as to computation of tax to be made at specified percentage ad valorem, without specifying which price is taken into consideration for levy of tax, namely the sale price or the purchase price of the concerned scheduled goods. It was said that sale price and purchase price of a dealer would be different, and in the absence of any guideline in the charging section or any other provision in the Act, it would lead to arbitrary determination or computation of tax by taking in one case sale price of the scheduled goods and in the other purchase price. The contention overlooks the specific guideline to be found in the charging section itself. The taxing event is the entry of scheduled goods into a local area. The tax becomes payable on the entry of scheduled goods in local area. Therefore, the price of the scheduled goods at the time of entry paid by the dealer, who is the importer of goods within the scheduled area, would be the ad valorem price on the basis of which tax will be computed. No subsequent rise or fall in price has any relevance to the computation of tax. The charging section says that the tax is levied and collected on the entry of scheduled goods in a local area at specified percentage, not exceeding 2% ad valorem, in our case 12%. Therefore, the price of the scheduled goods at the time when the tax becomes chargeable, irrespective of the fact that it will be computed at a later date when the dealer submits its return, as required by other provisions of the Act, would be the price for computation of tax. And there is no ambiguity or any vagueness in this behalf. There is the specific guideline in the charging section itself for taking note on account of the price according to which the tax should be computed. The High Court negated this contention by observing that it would be open to the dealer to choose either the sale price or the purchase price, whichever is favorable to him for computation of the liability tax. This approach overlooks the specific language of section 3, which clearly indicates what price is to be taken into account for computing the tax. When the goods are brought within the local area, they have a certain price. The price may be the price which the importer of the goods has paid before bringing the goods within the local area. Even if the dealer is the manufacturer of goods at a place outside the local area and brings the goods within the local area, he must have determined the price of the goods. Therefore, the dealer has some specific price of the scheduled goods which are being brought within the local area at the time of entry in the local area, and the entry being the taxable event. That would be the price which alone, yes, I am emphasizing this word. That would be the price alone which alone can be taken into account for computing the tax ad valorem. Therefore, we find it difficult to agree with the reasoning adopted by the High Court in rejecting the contention. But for the reasons here in the above, mentioned the contention is devoid of merit and accordingly it must be recognized. This is how Supreme put it, that value of the point of entry blocks. Then, yes, I will bring my lordship's attention to MP High Court judgment, which is directly on the point, that is Gujarat Steel Tubes. Your lordship will kindly see the question involved. What is the question? At page 8 belows.
14, right.
Sorry, page 14 is 14, page 1 of the judgment. So my lordship kindly say question below. Identical to your lordship, not in this case below.
Where is this judgment?
Same comparison. Page
Same
14.
comparison running page 14.
14.
Minus.
Yes.
Question is, when the goods are transferred by the manufacturer from head office to branch at the manufacturing cost price, whether entry tax will be payable on such cost price plus transport expenses or on the price the goods would fetch in the market, meaning that the open market price. Now, my lords, will kindly come to paragraph 5, next page. Paragraph 5 minutes. As noted above, the question is as to what basis entry tax is leviable. The dictionary meaning of the words entry is an act of entry, a passage, act of taking possession of, etc. The entire exercise should be to fill gaps, clear doubts, and mitigate hardships in the area of legislative ambiguities, if any. In the words of George Learnhand, it is a very pertinent Miller's findings of English judge. One of the surest indexes of mature and developed jurisprudence. Remember that statutes have some purpose or object to accomplish whose sympathetic and imaginative discovery is surest guide to their meaning. Then next para. What is imaginary here is that the goods at the point of entry into an area are chargeable. The inbuilt basis would be the total cost price at the point of entry and not at the time of exit or sell. It is the incidence of entry tax, not purchase or sales tax, which implies that elements like bouquet or profit are not eligible. The cost price indicative of pro forma invoice and transport charges should naturally be the fair criteria for the purpose of tax at the point of entry of goods in question. Next parameters. Law is not teleprosity. Because I have examined the meaning of the teleprosity from dictionary. That means towards dark or shadow. Law cannot be dark or shadowy. So therefore, this co-directed determination of the market value of the goods, deducting the expenses referable to the transaction from the sale price. In Hindustan Steels, Bursa Board of Revenue held that where the goods are manufactured in a factory, the expected price plus expenditure on freight up to the point of entry in the local area should constitute a fair basis for imposition of entry tax. Charging section 3(1) of the entry tax stipulates that tax is leviable on the entry of goods specified in schedule 2 in the course of business of dealer for use, consumption, sale therein. In case of purchase value can become the basis to determine the taxable quantum. In case of manufacture, as in the case on hand, market value for the purpose of entry tax should be expected price indicated in invoice plus transportation charges. Sale price fetchable after entry is to be higher than the value before entry. Entry tax is leviable on the point of entry of goods and before sale. It is the entry which is the tax event. It is clear that price which the goods will fetch in the market will be an irrelevant factor for the purpose of levy of entry tax. This is perhaps how Honorable MP High Court referring to judgment has been given. Now, next judgment of relying upon is perhaps Hindustan Steels case, which perhaps starts at page 17. And my lords will kindly see the question perhaps. That is at page 18. Whether the price shown by the head office in its invoices could be accepted as the market value as per section 2H of the Entry Tax Act. Let me skip the facts. I am directly taking my lord's attention to definition of value of goods, for which you also can have comparison with our definition of purchase value. My lords may kindly see page 20 below. The definition of provision is 2L, defining value of goods. Page 20 minus. Yes. That's 2L, value of goods in relation to a dealer or any person who has effected entry of goods into local area shall mean the purchase price of such goods as defined in clause KK of section 2 of the Sales Tax Act and shall include excise duty and additional excise duty, custom duty, if levied on Central Excise Salt Act, the additional duties of excise, goods of special importance act, or the customs act, as the case may be, or the market value of such goods, if they have been acquired or obtained other than by way of purchase. Because the last wordings are exactly similar to verbatim that of our provision to 2J. And next clause, question posed by the court clause is at the next page 21, paragraph 12. In the present case, where the goods have been transferred from factories of the associate to outside on consignment basis, what is the value on which entry tax is to charge? Now, my lords, kindly turn to only one paragraph, the 2 paragraphs will suffice. Paragraph 15, my lords, at page 22. In the present case, the iron and steel are controlled goods, and its selling price is fixed by the controller, who also fixes the invoice price in case of transfer of goods to the branches. I am taking a pause for a moment, below. I want to just refresh my lord's memory below the other day I have argued below. In this case, below, the lordship have seen particularly HSD, kerosene oil. The receipt price is much higher than the disposal price because it's a control item. Pricing policy is by the government of India, they fix the price below. So therefore, having dual approach, one adapting receipt and the other adapting sell, as adapted here, is not permissible. That is what here. Because it's a controller who also fixes the invoice price in the case of transfer of goods to branches. In such circumstances, the invoice price as per control order will be the purchase price for imposing of entry tax on the branch. This invoice price includes the freight charges up to branch also. This is the price on which goods are received by the branch. It should also be noted that entry tax is payable on the point of entry. The price which it will have at the time of entry of goods into local area. In the case of Commission of Sales Tax MP versus Samriddhi Trading Corporation, Indo, of this court, the Act describes the market price, but it does not describe the market price of the goods at the point of transfer or at the point of entry or at the point of sale therein. The purchase price relates to the value of the price from the goods moved. Similarly, the market value of the goods should be the value of goods of the place from which the goods moved. Next part. It has been noted that entry tax is on the entry of goods and not on the sale. If sale price is taken as the basis, then it will not remain entry tax on entry of goods because the sales depend upon the time when the goods are sold. If the goods are sold after 6 months, by that time, the price may go up or go down. Then on what price the entry tax will charge? Therefore, the sale price cannot be the basis of tax system. This is the findings of the Honorable Court. In view of this, we are of the opinion that in case assisted invoice price can be accepted as the market value as per 2H of the Entry Tax Act. That is that as paragraph 18 belongs. Next belongs. There are two judgments which just I will point out for Lordship what it speaks up. I will not take my Lord's attention so much to burden my Lord's. This is Tata Locomotives case and also Burma Oil's case, Lords. Because those two judgments speaks of because mere entry of goods into a local area does not involve tax liability because unless this is coupled with because use, consumption or sale therein. And what is sale therein was that is dealt in Burma sales case. And what is huge consumption? Suppose a person purchases petrol for his motorcycle in a local area and rides the motorcycle to another local area and he consumes there. He uses the motorcycle there. So therefore, if it's intended to be used there, then the criteria that is required for statutory purpose of consumption is satisfied. That is what belongs. But the fact remains, mere entry will not suffice unless this is coupled with the huge consumption and sale belongs. Then I will take my Lord's attention to very important judgment belongs, which is followed till today belongs in all taxes. It's a tenet of basic tenet of taxation. It's a my Lord may kindly see. It's a judgment starts from page 64. This is the case of Gobind Saran Gangasaran judgment belongs. To testify the validity of any taxing statute belongs, this is always followed belongs.
What is the page?
Page belongs to start from page 64. And the relevant page will be 69 belongs. One paragraph will suffice.
Yes.
Page 69, my Lords may kindly see this paragraph starts with the components.
Yes.
Yes. But the components which enter into the concept of a tax are well known. The first is the character of the imposition known by its nature, which prescribes the taxable event attracting the levy. The second is a clear indication of the person on whom the levy is imposed and who is obliged to pay the tax. The third is the rate at which tax is imposed. And the fourth is the measure or the value to which the rate will be applied for computing the tax liability. If those components are not clearly and definitely ascertainable, it is difficult to say that the levy exists in point of law. Any uncertainty or vagueness in the legislative scheme defining any of those components of the levy will be fatal to its validity. So therefore, four things, Vilas. One is taxable event, Vilas. And second is Vilas, person who is liable to pay tax. Third is the rate of tax. And fourth is the measure of tax for the purpose of application of rate Vilas for computation liability. But absence of any of the one among four Vilas will invalidate the statute. It will make the valid vulnerable Vilas. That is what I know. And this is followed Vilas. And the source of this judgment Vilas is Vilas. In 9 STC, in case of Gannon Dunkali, prior to purchasing amendment, the Constitutional Bench has dealt with, and this will be in very particular time also, the Constitutional Bench has also laid down the very attributes of cell which are to follow the laws. Unless these are there, a statute cannot be valid. Then, plus, I will take my lord's attention to one more judgment of another apex court belows. Though that judgment is related to sell, but conversely, it can be also applied to purchase, as your lordship is concerned in this batch of cases belows. So the principle is, I will take my lord's attention to this Rajasthan, state of Rajasthan versus Rajasthan Chemist Association. It starts from page 72, judgment. I will take my lord's attention to paragraph 24. That is at page 82. But here also, page 82, paragraph 24, my lords. Yes. So here, Honorable Apex Court again has referred to Govind Saran Ganga Saran's case, my lords, on analyzing Article 265. The components which enter the concept of a tax overlay. I will not repeat because these are already been, I have already placed for lordship from Ganga judgment verse. Then paragraph 25, my lords may kindly see. Obviously, all the four components of a particular concept of tax have to be interrelated, having a nexus with each other. Having identified tax event, tax cannot be levied on a person unconnected with the event, nor the measure or value to which the rate of tax can be applied can be altogether unconnected with the subject of tax, though the contours of the same may not be identified. Then you lordship may kindly turn to us, paragraph 30. At page 84, lords. Yes. Now, the question of tax on sale of goods may be examined in the same background. The subject of tax being sale, measure of tax for the purpose of quantification must retain nexus with sale, which is the subject of tax. Well, conversely, I have to understand that sale is purchase. Same principle applies, Miles. As noticed above, tax on sale of goods is tax on vendor in respect of his sales and is substantially a tax on sale price. The vendor or buyer cannot be taxed, diverse the subject of tax, that is sale by the vendor or purchase by the buyer. The four essential ingredients of any transaction of sale of goods include the price of the goods sold. Therefore, in any taxing event of sale, which becomes subject matter of tax, price component of such sale is an essential part of the taxing event. Therefore, the question does arise whether a particular taxing event of sale could be subjected to tax at the prescribed rate to be measured with such price, which is not the component of the transaction of sale which has attracted the sales tax. So therefore, if the taxing event and the measure of tax is related to this price component, then that's what price goes from the buyer to the seller constitutes the price on which was the measure of tax. It cannot reduce that price. We cannot have a price X hypothesis. That is what also Honorable Supervisor said. I am taking my notes after the next paragraph. That is paragraph 55. That is paragraph 55 is matter of page 89. Page 89, paragraph 65, minus. By devising a methodology in the matter of levy of tax on sale of goods, law prohibits taxing of a transaction which is not a completed sale and also confines sale of goods to mean sale as defined in the Act.
Here is some paragraphs are not here in the compilation.
Yes, sir, in the right hand side, I also find the paragraph in yours.
Page 89.
Page 89.
Oh no, this after 51, there is no paragraphs like 55. It then goes to 57 and 58.
Right side.
May I bring the right hand side? Internal page
559.
559. 559.
559 is there. It is
Yes, right hand side, the serial numbers are there, paragraph things are there. These days, some journalists are mentioning paragraph right hand.
Oh, okay, that way.
Yes, nurse.
It's a placitum.
Yes, yes. Paragraph 55, nurse.
It's not paragraph, this is a placitum 55, okay.
Yes, sir. By dividing your authority, yes, my right. Yes. By dividing your authority in the matter of levy of tax on sale of goods, law prohibits taxing of a transaction which is not a completed sale and also confines sale of goods to men, sale as defined in the Act. This cannot be overridden by dividing measure of tax which relate to an event which are not come into existence or when tax is ex hypothesis determined, much less which can be said to be completed sale and which cannot be subject legislation providing tax on sale of goods by transplanting a sum related likely price to be charged for subsequent sale to be taxed by the device of measuring tax for the complete transaction which has become subject of tax. Because next minutes, I will draw my lord's attention to Bharat Aluminium Company. It starts from page 96, para 3.
Page 98.
Page 98, my lords.
Yes.
Shri SUBHASIS and Council for the Assessor have invited attention to definition of value of goods as defined in section 2(1) of the Entry Tax Act, which is under. Value of goods in relation to a dealer or the person who has effected entry of goods in local area shall mean the purchase price of such goods as defined in clause O of section 2 of Sales Tax Act and shall include excise duty and additional excise duty if levied under Central Excise and Salt Act and the additional duties Excise Goods Social Importance Act or the market value of such goods which they have been acquired or obtained or by your purchase. Then there's para 5. 4 I am skipping para 5 minutes. At page 100, running page 100. Having regard to the fact and circumstance case, we are of the opinion that as per definition of value of goods as defined in section 2A of the MP General Sales Tax Act, the freight charges are to be excluded from working out the sale price of the goods for being subject to tax, entry tax. In the present case, rupees 117 metric ton was landed cost of the bauxite of the assessee that included freight charges is shown as average at the rate of so per metric ton. This has to be excluded and the authorities seem to have not looked into the matter from that view and has taken rupees 100 to market value of goods. That approach the authority below was not correct. The authorities should have examined the matter and should have properly apprised themselves of the record and being before arriving at a conclusion. In fact, partly the applicant assessee itself is responsible because didn't file a return. If he had filed a return, perhaps this mistake would not result. However, after going through the statement measure of bauxite consumed and nature of mentioned therein, your opinion that 117 metric ton was the landed price at the plant which included freight charges. Therefore, after deducting this, the price will come to 70 rupees per metric ton, 70.79, and assessee accessible at this rate on the goods brought to tax. That's the uncertainty. Then last judgment, which is the judgment relied upon by the other developers, I have brought to my lord's notice page 53 of the judgment. Page. Last page. Then last word of that. Perhaps page 57 of the brief laws, wherein your lordship will find that the entire determination of the purchase value made by the assessing authority is based upon the judgment of Karnataka High Court in the case of Voltas Limited Bills. That's the only ground as per the assessing authority because of 2J, section 2J, and the judgment of Honorable Karnataka High Court in Voltas case belongs. They have relied upon. Now, my lordship, kindly I am taking your lordship to attend to Voltas judgment.
Yes.
The provision under the Entry Tax Act in Voltas case, in which Honorable Karnataka High Court is concerned, was section 2A bracketed small 8A of the that act name is the Karnataka Act. The name of the act is Karnataka Tax on Entry of Goods into Local Area for Consumption, Use or Sale therein Act. Whether the provisions of their act is similar to as that of our 2G of the Orissa Entity Tax Act, one. Number two, whether the Honorable Karnataka High Court has bureaus, even though reproduced the judgment of the Honorable Hansa Corporation Judgment Bureaus, yes, but the findings still also will find what is the findings. First of all, you will also kindly see the provision at page 108 of the compilation. Is the definition of value of goods as defined under section 208A of the Act reads thus: value of goods shall mean the purchase of such goods. That is to say, the purchase price at which a dealer has purchased the goods, inclusive of charges borne by him as cost of transportation, packing, forwarding and handling charges, commission, insurance charges, duties and the like. Or if such goods have not been purchased by him, the prevailing market price of such goods in the local area. This is the language bureaus. Now, your Lordship, kindly turn to next page. In the next page, my Lordship will find the Honorable Court has referred to the decision in the case of State of Karnataka versus Hansa Corporation, Air 81 Supreme Court 460, strongly relied upon by Sri Kumar. No doubt supports his contention. I am reading from middle mirrors that even if the dealer is a manufacturer of goods at a place outside the local area and brings the goods within the local area, since at the time of entry of goods in the local area, the dealer would have determined the price of the goods. He is required to pay the tax based on the price of the goods. In this contention, it is useful to refer to observation made by the Honorable Supreme Court, para 30 judgment. I will not repeat para 38, which I have already read from Hansa Corporation Judgment Belows. And after reproducing paragraph 38, the operative portion of judgment in Hansa Corporation laws, your Lordship will find how the Honorable Court has dealt with. That my Lordship will find from page 110 of the compilation. Next page. In our view, my Lordship, yes. In our view, the principle enunciated by the Supreme Court in the case of State of Karnataka versus Hansa Corporation, Air 81 Supreme Court, has no application to the fact of the present case. Because how could no deliberation, no analysis belongs, nothing belongs, there is no application. Then, as noticed by us, earlier section 2A8 of the Act, as amended, which has come into force with effect from 1st May 92, makes it clear that in case of the goods which have not been purchased by dealer, if they are brought into a local area, the value of the said goods is required or to determine on the basis of the prevailing market price of such goods in local area. Therefore, the liability to pay entry tax on the goods which enters the local area would be on the basis of the market price of such goods in the local area on the date of the entry. Here it is necessary to notice the distinction between the sale price of this said goods by the dealer who gets the goods within the local area and the prevailing market price of such goods on the date of entry of the said goods in local area. What is contemplated is the determination of the market value of the goods when the goods enter the local area and not the market price or sale price of such goods on a later date. In the light of the view expressed above, we are of the opinion that the judgment of Madhya Pradesh High Court in the case of Commission of Sarsan versus Hindustan Steels has no application to the case of the petitioner. When section 2A8A specifically provides for determination of the market value of the goods, as noticed by us earlier, it is not permissible to determine the market price of the goods in a manner other than the one provided under section 2A8 of the Act. If the market price as shown by the petitioner is on stock transfer basis, the determination of the said market value would run counter to the mandate of section 2A8 of the Act. That cannot be permitted. In the instant case, the assessing authority, in the absence of any material placed by the petitioner with regard to prevailing market price of the goods which have entered local area, has proposed to add gross profit of 15.5% to the stock of refrigerator, proceeded to buy levy entry tax so far as air conditioners parts are concerned. He proceeded to determine entry tax on the basis of such sale. Because thereafter somehow we reduced the percentage, but the question is, so far as Honorable Karnataka High Court judgment is concerned, which is relied upon by the revenue bureaus, to 45, their case in support of the demand they have raised to us. Whereas Hansard Corporation judgment lordship found is reproduced. Whereas no analysis is happening, how no attempt is made to distribute it also. They do not say that it can. They said there is no application at all. How can one can say so with great respect? One. Number two, what the Honorable Court has done. The provision of section 2A18. Court went by the language of law without comparing rates or considering.
The whole argument of yours is that in the basis of the Supreme Court judgment, the Karnataka High Court judgment may not be given that amount of importance that has been given by the tribunal.
Correct.
And the second is that we can independently look into the ratio that has been laid down by the Supreme Court judgment.
Correct.
So if we find there is any conflict, the absence of proper reasoning, not to declare that judgment relevant, in absence of relevance, we cannot also apply that judgment and can interfere also.
Correct. Next is one judge which I have added the proper legal proposition I have advanced minutes. Plus section 2J. 2J cannot run counter to section 3, which is argument provision. As my lords have seen from Gangasaran.
No, that is I have a question to you. We can look it from a different perspective also. Because today you just begin your argument by saying that section 2J must be subservient to section 3.
Correct.
Right? So where is the challenge? Because by way of interpret, we can read down the other components of section 2J also. And we say the primacy must be given under section 3. So whatever the other definitions or other component can be brought inside, they can only be brought inside of the taxing if this goes through the filtering of section 3.
Correct.
So where is the challenge then? You are talking of adjustment of two sections.
My humble submission is, the other day I have pointed out to lordship bills the counter affidavit filed by the revenue bills. According to the revenue bills, 2J is the measure of tax. That is the specific content in bills. And they say why it is measure of tax? Because the invoice,
usually the definition clause is the measure of tax.
Definitely. Usually, if it contains bills, the measure of tax. Your lordship is correct. I also admit bills. But your lordship found section 2J so rule 17, which is there. That doesn't provide any mechanism to determine the value when the goods are obtained or acquired other than by your purchase. Yes. So far purchase of goods is concerned, there is no quarrel with us. There is no quarrel because it is supported in invoice. Yes, when goods are acquired.
Only dispute was the value of goods.
Correct, the value of goods.
That's all.
Value of goods. And in relation to goods when obtained or acquired other than by your purchase, like stock transfer, like that's when the goods are sent by principal to agent bills. Even bills. When I am, suppose I am a government employee. Because I have some goods which I am bringing from Kolkata on my transport to Odisha bills. And those are taxable scheduled goods because furniture, TV, whatever I am bringing bills. Because unlike other acts, there are some acts bills where they say in course of business. In our act bills, not only dealer, the person who in course of business brings, any person bills. Therefore, the language of 3.2 is the person who takes delivery of or the intent to do delivery of. Any person can lie with the tax bills for that matter. There is in course of argument in one of the matters, it so happened, Mr. Mahathi was arguing, Vijay Krishna Mahathi. He said that even if dead body comes in a coffin with us, because a coffin is taxable, dead body is well. But coffin is a article, so therefore that can be taxed also. So therefore, my humble submission is, therefore 2J cannot be read due to section 3. Section 3
is your principal argument.
So correct, absolutely correct. And it is a situation which has arisen in case of deluxe wines case in Andhra Pradesh bills. Honorable Andhra Pradesh High Court said that there are certain words which statute like prevailing market price, abnormally low. Yes, sir. Those are the questions, situations bills which got undefined in the statute bills. And Honorable Andhra Pradesh High Court, I have also annexed the compilation. You also will find the last judgment. In the compilation, deluxe wine versus state of Andhra Pradesh, 1990, STC 373.
It is in the compilation.
This is a compilation. There Honorable High Court said, one thing, Honorable High Court said, when there was in absence of the definition of those wills and any mechanism, when determination is not possible and the provision cannot be worked out, so no levy can be made until the legislature put in place such a mechanism by framing rules wills. So till then no recovery wills. Nothing, no demand can be raised wills. It can only be made after government comes up with a legislation providing for mechanism. That is what Honorable you also will find from Deluxe Wines case wills. And one judgment which I have left wills, this Travancore chemicals case wills, there Honorable Supreme Court said that it only may your lordship permission wills only 2 paragraphs let me place wills.
In from Travancore?
Yes, 115 wills. The letters are a little bit small, you will also kindly bear with. Paragraph 11. Running page 117.
Yes.
Yes, there is no warrant, in our opinion, in trying to redound the provisions of section 59A. The words of the said provision are clear and unambiguous. The said section gives absolute power to the government to decide any question regarding the rate of tax leviable on the sale or purchase of goods in any manner it deems proper, and finality is given to such a decision. Section 59A enables the government to pass an administrative order which has the effect of negating the statutory provisions of appeal, revision, etc. contained in chapter 7 of the Act, which would have enabled the appellate review authority to decide upon question in relation to which an order under section 59A is passed. Quasi-judicial or judicial determination stands replaced by the power to take an administrative decision. There is nothing in 59A which debars the government from exercising power even after a dealer has succeeded in a question relating to rate of tax with an appellate authority. The power of the 59A is so wide and unwavering that it can exercise any time, and the decision so renders to be final. It may be well that the effect of this would be that such a decision may even attempt to override the appellate revision power exercised by the High Court under section 40 of the Act, as the case may be. The section enables passing of an executive order which has the effect of subverting the scheme of quasi-judicial and judicial resolution. Then last para, the aforesaid section itself provides that the question for determination must arise other than in proceeding before a court or before the commissioner has commenced assessment here. Furthermore, subsection 2 enables commissioner to direct that determination questions shall not affect liability of any personal right act with respect to any sale affected prior to determination. Most of safeguard and guidelines as provided under section 49 the Henry Sales Tax Act is present in the main provision. So we have in complete agreement with Kerala High Court. So therefore, unguided and uncanonized power cannot be allowed to be vested with the quasi-judicial authorities. Otherwise, there will be anarchy. Two more judgments I have filed with us along with one additional memo. One is in the case of Gas Authority of India Limited versus Commissioner of Commercial Tax. Paragraph 3, by Lords, may kindly see the question, Lords. Paragraph 3.
Yes.
Whether section 2H of the UP tax on entry of goods into Local Areas Act 2007, having defined value of goods as the purchase price of such goods, which paid by the importer for the purchase of such goods and the applicant having admittedly purchased natural gas from ONGC Limited, Hagaria, whether the tribunal is not justified to uphold imposition of entry tax on the sale price, that is the market value of the natural gas. 2, whether the entry tax being payable on the value of goods which enters the local area of Agra, hence the applicant liable to pay entry tax on the purchase price, which the applicant has paid to ONGC Limited for purchase of natural gas, and no entry tax can be demanded on the sale price at which the natural gas is subsequently sold by the applicant to the customers which is illegally treated as market value by the department. Question number 3, whether under section 4 of the Act, entry tax rate of 3% is to be held paid on the value of the goods and defined on 2 HI Tax Act. Hence, the market value of the goods will only be taken into account when the goods have been acquired, other than by your purchase. Then paragraph 5 of the judgment refers to value of goods are determined as ascertained from original purchase invoice or bill. The charges which are included include value of packing material, packing foreign charges. If this is also there in our statute, then therefore all different heads of charges which are added so as to bring the goods in local area where it has to consume, use or sell only can be added by the charges incurred inside the local area. If any would not come within the term value of goods, I defined at 2 H of that. Moreover, value of goods can be equated or identified with the sale price of the goods by importing in the local area. The entry of goods visualizes 3 kinds of import. Firstly, one, since goods are bought in local area from any place outside such area, therefore the cost of purchase outside such local area and all other incidental charges incurred to bring such goods in local area can be included in the value of goods. But the sale price of the dealer imported to its consumers would not be the value of goods, which may include charges or expenses, if any, incurred inside local area and the profit margin, etc. Similarly, the provision in respect of Res 2, where the goods are brought from outside the state into local area or from outside the country into local area for consumption, use or sale. The term consumption, use or sale in local area has been used for the purpose of considering territorial jurisdiction of local area, at which point entry tax would be chargeable and not for any other purpose. In my view, the decision rendered in apex court in case of State of Kannada versus Hansa Corporation would be helpful in the present case, wherein the court referring to perimeter provisions of Karnataka said. Then they quoted the provision, para 38. Then lastly, para 7, the above observations are attracted squarely in the present case also. Under the Hansa Corporation is followed. In view of the above discussion, otherwise, taken by travel is clear evidence unsustainable. The question formulated therefore answered by observing that expenses incurred, if any, by revisionist necessary for transporting goods to local area where it is consumed, used, sold, and not a part of value of goods for the purpose of tax held under Act 2007, but itself confined up to the stage where the goods are brought inside the local area. So up to point of entry, all incidental expenses incurred, that is that includable, but not beyond bills. Then the last judgment bills, which I have to place your worship, is Castro India's case bills. That is short judgment. There's one paragraph 10 may kindly be referred to page 7. Paragraph 10 minutes.
Can you give the citation? That is the citation, long citation above the judgment.
Yes, Your Lordship. I'll give a SCC citation, Your Lordship.
Must be 12.
Plus page 7, paragraph 10 minutes. Paragraph 10 minutes, yes. Page 7, yes. The Entry Tax Act has been enacted to levy a tax on entry of goods in local area in the state of MP for consumption use held therein. The entry of goods in local area as defined in section 2AA and as per section 2B, entry tax means a tax on entry of goods in local area for consumption use or sale therein, levied and paid in the account of this act. The value of goods is defined under section 2L and according to which the value of goods in relation to a dealer or any person who has effected entry of goods into local area shall mean the purchase price of such goods as defined in section clause S subsection 2 of that act and shall include excise duty or additional excise duty and customs duty if levied under Central Excise Act. But it is clear from the upper definition that the entry tax is leviable on an entry of goods on the value of such goods and treated value of goods. The appellant has shown the value of goods in Form F at the time of entry of the goods in local area. Now, paragraph 30, the last paragraph, the concluding paragraph 13. This contains the liability rejected for the simple reason in the Entry Tax Act or VAT Act there is no conception of ELP. ELP is a device by the appellant. That price is either contemporary statute or ELP as the sale price. This is a nomenclature developed by the petitioner in its internal transaction. The entry tax is levied at the time of entry of the goods in local area, which the appellant has shown in Form F. Even if the appellant sells its goods at reduced price or higher rate, will not be considered for charging of entry tax because the entry tax is liable to be charged at the time of the entry of the goods and not at the time of sale or consumption of the goods into local market. ELP is involved by the appellant only for the sale of the goods in the market. Section 3 clearly provides that the incidence taxation according to which on the entry in the course of business or dealer goods specified in Schedule 2 there shall be levy of entry tax in Form S. The appellant has declared the price of the goods which have rightly been considered by taxing authority for the purpose of levy of a tax, which is the value of the goods as per definition given in 2L. So therefore now referring to, so this is allowed. It is the case of the, so now my humble submission is, yes.
This para 20 of this industrial laboratories, below this para that you just last para, they have quoted it, para 14.
Para 14, minus.
Yes.
Section 2 says the VAT Act defines purchase price.
No, this is go down to the sub para 11.
Para 15.
Para 11, yes. In interpreting taxing statute, equitable considerations are entirely out of place. Nor can taxing statute be interpreted on any presumption assumptions. The court must look squarely at the words of the statute and interpret them. It must interpret the taxing statute in the light of what is clearly expressed. It cannot imply anything which is not expressed. It cannot import provisions in the statute as to supply of any assumed deficiency. Plus, this is followed with so many judgments, like Goodyear India.
This is a lot of judgments are there.
Yes, lot of judgments are there.
Yes.
But the fact remains with us, the constitutional entry cannot be compromised. Entry 52. That is paramount. That is source of legislative field from where entry tax act has barred. After this, some subsumption of 131 KT of the Orissa Municipal Act, this act has barred. Now the question is, value at the point of entry, that is the Miller's dogma, the principle, maxim of Supreme Court has, starting from Hansa, it has been followed till now. It has not been subverted. That judgment still stands. So therefore, one more logic advanced by
the local area doesn't mean the first entry. Local area doesn't mean when the goods is delivered for purpose of sale and the transfer.
That is left to my loss. I understand.
Otherwise, it will create a lot of complications. Because this is the pricing, not in the present concept. Pricing in the local area is what's actually couched with the local area in some part of the statute. But pricing in the local area means what price actually it is sold out.
But may I give one proposition to us? So what will happen? As my Lord knows, Rule 10, Section 10, it says that if Section 3 itself also explanation says that if tax has been paid by any person or any dealer, it will not be liable for further tax. Supposing tax is discharged at the point of first entry. So therefore, till the goods move through successive local areas, till it reaches the ultimate destination, where the business of the consignee located, there will be no further levy of entry tax.
Tax somewhere, some other way it has been defined. You just carefully look into this matter. This is the pricing in the local area.
Whether first or subsequent or the end.
No, because this word, the word is couched in a way, the pricing in the local area or something indicates to a definiteness of the word. It is not a very vague statement in the statute. So that also sometimes can give us some light to understand what is the actual, how to the value of goods. So for the entry tax is concerned has to be assessed.
Correct. But one thing your worship has to keep in mind, 2J cannot be read during Section 3.
Obvious. That is
my ambition. That is
that is the principle.
Whereas the entire thing can stand Section below. Cannot stand because the 3 charging provision, which is the spine of the enactment, that speaks of purchase value. Purchase value denotes its own inbuilt expression and intent that everyone understands. And it speaks of two things. One, when supported by purchase simpliciter, normal buyer-seller, and other than buyer-seller relationship when goods are consigned by principal to agent or one to other than by a purchase. In that case, what is the measure of tax? The Lordship will certainly admit fairly that neither section 2J nor 17 provides any mechanism to determine this aspect.
All right, that is why I asked Mr. Mishra also, I will ask this question. When suppose goods are being transferred and transported to the local area with invoice.
Correct.
What are the other measures they can apply to that except the invoice price? That's all. And in that case, the difference that was showing in the SQO versus other products, the assumed price.
Assumed price.
Price and hypothesis. That is permissible or not.
Correct.
That's all.
I think
that's all. I think. Just Mr. Kaur, would you like to supplement?
No, I completely agree with my learned friend. I adopt the entire argument.
Okay.
I just raise one legal issue with your lordships.
Is as you sorry, just one sentence I'm adding. I'm extremely sorry. The revenue have referred to prevailing market price, referring to section 234 of the Odisha Manual Tax Act, because the Odisha Entity Tax Act says per watts and export not defined in Tax Act.
That will be
that one. But prevailing market price definition of Odisha Manual Tax Act that also doesn't provide mechanism.
Section 234.
That also doesn't provide any mechanism. And the language
234 or only 34?
No, section 2 bracketed 34
that is
of the Odisha Value Added Tax Act.
That is what I'm telling you.
Yes, my lord. And the expression used is similar to that of 2J. Doesn't know mechanism, nothing. Deeply.
Yes, Mr. Kaur.
So I adopt the argument of my learned senior friend, Manoj. Your lordships have seen that so far as the provisor to 2J is concerned,
yes,
all these matters and all these cases before your lordships deal with cases where the goods are purchased otherwise than by way of brought in otherwise by way of purchase. So in my humble submission, Lord, this says that the goods are entering into the state of Odisha. So far as state of Odisha is concerned, by virtue of a notification, the entire state has also been declared as a local area.
Exactly.
So if the entire state is a local area, as your lordship says, the subsequent entries within the state will not be of much relevance so far as these cases are concerned. So whatever is...
What is that notification that you...
Offhand, Lords, I'm trying to collect that. Whether the entire area or the state has become a local area. I'll give that...
No, that is permissible.
That is permissible.
Yes.
And so far as your lordship's query, which was being put to my learned senior friend, Milords, is what happens if the price is entering from one local area into the other local area?
Oh, I asked only, this is only to him because he raised that question.
My humble submission would be that they bring us into the proviso because these...
Give this notification. Whereby it has been declared the entire state for purpose of the Odisha Entry Tax Act. Entire state is a local area.
I'll also request my learned junior friend also to give that note. So here, my lord, the question is that the scheduled goods are obtained otherwise by way of purchase. So this otherwise by way of purchase, my lords, is either a stock transfer from one state to another, or a branch transfer, or an agency sale. Now, if your lordship would kindly take up the CST Act, my lords.
Yes. CST Act.
Yes. Your lordship knows about section 3 about the interstate sales. So far as goods brought in otherwise by way of purchase is covered under section 6A.
Yes.
Your lordship got it? Burden of proof, etc. in case of transfer of goods claimed otherwise than by way of sale. May I just place it notes though. Where any dealer claims that he is not liable to pay tax under this act in respect of any goods on the ground that the movement of such goods from one state to another was occasioned by reasons of transfer of such goods by him to any other place of his business or to his agent or principal, as the case may be, and not by reason of sale, the burden of proving that the movement of those goods was so occasioned shall be on that dealer, and for this purpose he may furnish to the assessing authority within the prescribed time or within such further time as the authority may, for sufficient cause permit, a declaration duly filled and signed by the principal officer of the other place of business or his agent or principal, as the case may be, containing the prescribed particulars in the prescribed form obtained from the prescribed authority, along with the evidence of dispatch of goods. And if the dealer fails to furnish such a declaration, then the movement of such goods shall be deemed for all purposes of this act to have been occasioned as a result of sale. Then at this juncture, your lordship may kindly turn to Rule 12.5 of the CST registration and turnover rules. Lordship got if your lordships are holding this book.
Yes, yes.
Registration and turnover rules.
You are referring to rule?
I'm referring to Rule 12.5. That your lordship would get it at.
Yes, I'm getting 12.5.
12.5.
The declaration referred to section.
Referred to subsection 1 of section 6A shall be in form F. I need not bother your lordship with the rest of it. Then your lordship may see what is the content of that form F, my lords. Lordship got the form F. Then your lordship would see, if your lordship would come to the your lordship got it?
Just a minute. Yes.
It has 3 parts. To the bottom notes, to so-and-so transferor, so-and-so registration certificate number of the transferor. Certified that the goods transferred by me as per the details below have been received and duly accounted for. And what are the things given? Description of the goods transferred sent, quantity of weight, value of the goods. Lordship got it, notes?
Yes.
So the value of the goods are declared in Form F, and Form F, my lord, is bound to be produced in order to prove that there's a branch transfer or there's a purchase other than by way of sale or a stock transfer. So if this value of goods, and in my learned friend, my lord, for the other side, does not raise the contention that in any of these cases, they have said that it is not a sale under 6A, but under section 3. So having not disputed it, having accepted the value of the goods declared in Form F, my lords, then, my lord, labeling these goods that since they have come by otherwise by way of purchase, so if the proviso to section 2J applies, and therefore you have to pay on the sale value of the goods does not arise. So because this value of goods is ascertainable, in my CST registration, you have accepted my transaction to be a branch transfer, and you have accepted my transaction to be a stock transfer or agency sale, whatever. And then you have accepted this value as declared in the Form F.
Stocks and inverse also and value.
And this stock, sorry?
Stocks and inverse also mentioned the value.
Right. So,
right.
So, weighting also declares the value. So, and weighting, my lord, is also a necessary concomitant for proving that there's an interstate movement of goods. And this Form F is a statutory form.
Yes.
And this is not within the arena of conjunctions or surmises where the value of goods are not to be determined or cannot be determined. Yeah. So once you have a statutory form, once you accept the statutory form, you accept the value of the goods therein.
What about, in this regard, what about your stand about section 6A?
Yes, ma'am.
Section 6A.
No, section 6A, my lord, supposing, my lord, section 6A is accepted in all these cases. So once you accept section 6A, you accept my Form F. So without Form F, you cannot put me into the 6A bracket.
Okay.
So once you accept my Form F, you also accept the value declared therein. Once that is the value declared, my lords, that will be the value at the point of entry.
You mean to say that the burden on the SSC would only shift when that declaration is questioned by the SSC?
My lords. So once that is not being questioned, and my learned senior lord has also placed reliance on Rule 17. And Rule 17, if at the cost of reputation, if I just placed before your lordship notes.
Or you give your note of submission.
I'll pay it. This will be only my additional point of law.
That is why.
And I'll just place Rule 17 for a moment. Yes. Lordship got 17 minutes? Yes. Deduction, exemption, and assessment of tax. Of the Entry Tax Act.
Yes.
Lordship got Rule 17. Yes. In determining the purchase value liable to tax under the Act, the amount relating to the purchases made within the local area from a registered dealer carrying on business in the same local area shall be declared. The purchase value shall be determined on the basis of the invoices unless the same are rejected for reasons to be recorded in writing and after giving reasonable opportunity of being heard to the dealer. So this cannot be just brushed away lightly, Manoj. If you do not accept my price, you cannot jump immediately to 2J. You have to give reasons that yes, this is for the reason why for not accepting.
Yes.
And there has to be a reasonable cause for adopting the proviso to 2J, Manoj. And this particular exercise having not been done, in addition to my earlier argument that having accepted my Form F, you cannot question the value of the goods. If at all you question the value of my goods, then the other part of it is you do not accept my 6A sales. You put me under the Section 3, that is interstate sales, and you levy a tax on that. It can't be a tax-free so far as the CST Act is concerned. For 3 laws, if at all these things are given a go by, if at all you have to again do it, you have to reject that price and you have to do it for reasons to be recorded in writing, and then you adopt a figure. And I need not repeat, my lord, that the field of legislation is entry 52, and what they have done is, in the garb of entry tax, they have resorted to entry 54 of list 2, my lords. That's a tax on sale. And if in the worst case, my lord, against me, that if at all you have to adopt, you could have adopted the purchase prices of the goods available in the market, not the sale price, so that it will be in consonance with entry 52, and you do not have to resort to entry 54, which is not permissible. And your lordship would appreciate, lords, 2 groups, one with the invoice, one with the stock transfer note, lords. So far as the invoice part of it is concerned, you accept it. And so far as the stock transfer part of it is concerned, you say the same price of similar goods being sold would be the purchase price of your goods. So that is the problem. That will be all my submission in addition to what my learned senior friend has said.
Lord, I have 4 tax revision, but that is slightly different because in the Forest Development Corporation Act, royalty has been fixed and royalty has been defined under the Act, and royalty has been decided by this court in the forest product that royalty is the purchase price. You'll also kindly see the except in other cases, I follow both the judgment, judge argument.
This issue has been rated. What is the revision numbers?
51 to 55. That is, the depiction is the Forest Development Corporation. Here, the question has been framed the same issues, but the fact remains, if you also see the judgment of this honorable court, if you also is 14 VSP.
This is decided by the Honorable Court. If your lordship straightway to look into the this forest product and whatever the royalty is paid to the DFO, that is stated to the price, purchase price under the OST Act.
Yes.
If not, that has been
You are referring to exactly that.
Sorry, Lord?
But which paragraph you are?
Yes, Lord. I am just placing, Lord, the paragraph 15 and 16. There were other previous two cases as we consider, Arpit Tata and the Equal Brothers. You'll also straightway to 14 and 15, and starts from page
516.
Yes, Lord. 12 in 15, Lord. Internal page 517. From plain reading, Lord. For plain reading of the agreement of the forest contract as entered into between the governor of the Orissa and the petitioner is amply clear that the seller in this case is the government of Orissa and buyer is the petitioner under the contract. Under the contract, the petitioner is liable to pay the consideration as specified to the government of Orissa. On payment of consideration amount to the government of Orissa, the petitioner acquires exclusive right to procure termite from the lease out area during lease period. After acquiring the right to procure the termite from the lease out area on payment of consideration money, the government of Orissa, nothing is done by the seller. The government of Orissa procurement termite by the petitioner is become also responsible petitioner to produce termite from the lease out area at its own cost, and the considered royalty paid by the petitioner government is the purchase price. So therefore, Lord, in my case, if your lordship see, I paid on the royalty amount in addition to the other expenses, I paid the tax plan. Now the other
expenses means the transport.
Other thing, as per the act, I have paid the tax. Now the revenue come up with a fee that the price is not acceptable. Therefore, you have to pay the price and sale price. Even assuming that, if you also see the Forest Development Act, you will also see Orissa Forest Development Tax on Sale of Forest Products of Government of Orissa Forest Development Act 2003. Let's kindly have a glance. Here the government of Orissa determine the sale price. If you also see this section 2H. That from section definition G, then Lord, I will place the H. G is saying, Lord, sale or sale of product means by sale of forest product by and behalf of the government or the Forest Development Corporation for cash or deferred payment to other valuable consideration, whether described as a sale price, purchase price, or royalty, and includes any such sale of forest product by a cooperative society on behalf of the government or Forest Development Corporation. Next one. Meaning of sale price. Sale price means the amount of valuable consideration described as a sale price or purchase price or royalty paid or payable by the purchaser for sale or any forest product to him, and otherwise sale and purchase with their respective grammatical variation contains patients shall be construed accordingly. Therefore, Lord, in my case, Lord, 5 cases, Lord, royalty has been issued on the royalty in addition to other charges. I have paid the interest. There is no question. Now you will also see my one order of the travel. Lordship kindly, I'll satisfy Lordship is 51. Kindly see the brief 51 and the order of the travel. What is not held. It starts from interest 21. Yes. before that, Lordship, kindly page 16 for a moment. The order of assessment is.
Please ignore this straight 51 of 26.
No, prior to that, Lordship, kindly have a glance page 16 of internal page 16, the assessment order. There they clearly stated, they admitted, the assessment admitted that I paid the royalty in interest on additional royalty and the other insurance charges. Lordship, kindly see page 16 for a moment. Then I'll take your Lordship to order of the traveling.
Yes.
A last above 8 line.
Yes.
The dealer further state that they have paid ET on royalty only relating to the purchase price of timber. They did also furnish ET payable calculation statement by arriving purchase price, adding royalty, transport charges, or other charge together at the time of assessment. So there is no qual at all. Now you will also see the running page 21, order of assessment. Yes, sorry, I ordered tribunal. Next page, look, para 2.
Yes.
In instant case, the dealer is a government of police undertaking and is engaged purchase and sale of scheduled goods like timber, kindling, farming, pickles, and squash, etc. The fact of the case in brief that the dealer appellant used to produce timber, etc. on payment of royalty on the paid-well division or DFA, and after adding the transportation and other additional charges, determine purchase price accordingly paid the interest. On the other hand, the basing on the audit basis where it alleged that the dealer appellant has not paid the entry tax on sale value of the scheduled goods, thereby paid less amount of tax. The lender did not accept the claim of the payment of entry tax on the purchase value so determined by him, that is royalty paid plus transport and other charges taken into consideration. They will arrive to conclusion of the judgment of the that is not applicable, is relying on the revenue, relying on judgment of 142 STC, Gujarat Ambuja Cement.
Yes.
That is something different. If your Lordship, this is a case relating to this is related to royalty under the Mines Mineral Acts. When there is a definition is given under the government has defined royalty is a purchase price and sell price, and these are not called held under the OST Act, that is the purchase value, and doing the government of Orissa undertaking on the royalty addition, others I paid the tax, entry into scheduled goods into local area. Therefore, my submission would be I am not qualified to be RD2J. There is no value, no document, nothing. And in 5 cases,
51 to 54, almost to the
same issues. But inadvertently, the last 2 the question was something different. That is not properly. It was some other. It was I think 50. First 2, 3 in this question law correctly reflected, but other cases that has
in all the cases, question of law already framed.
For the petition, question of the same, but inadvertently the question of law in 2 cases, last 2 cases, not wrongly or I mean say wrongly, but 55 and 56 will not 56 and
these are somewhat different.
Yes, the case is the same, but the question of law will not enter into referred by these report will not slightly not different. It may be other cases it will be reflected. Other cases, other question of law.
Just give a note there.
Yes, ma'am.
Because otherwise it will be confused.
Right. So this is how many substance law.
Similar way, all the cases have been treated, I believe, now 51 to 56.
15 or 53, the question is very correct.
Same. But
I'll just give you
56 is somewhat different.
Yes, but I will just
do it. Please by tomorrow.
That is not the sum and substance my case. So, and the WPC 18040/2015. There will have challenge being 2J Lord, here is a case, Lord, I have a tax transfer, and tax transfer invoice, the value is there. I have, Lord, used the A form, value is there. I use, Lord, OAD, that is verified subsequently and accepted the value. And when there is the ascertainable value, there is no question of further ascertainable without any mechanism. So there is a power of arbitrary power. Lord.
Why is the, you have challenged this to J? What is the
case number, Lord, 18046/2015. In batch of cases, this case. 18046 of 2015. That is WBC, Lord.
Okay.
So my lord, I am in STRU number 50 by 2016 of the same batch, my lord.
Okay.
This is a revision petition, my lord, of the Pune Elaborate India Limited Lordships. I moreover,
yes,
moreover, under
your case also of 2015 or 16.
It is 16/2016, my lord. 50 of 2016. I moreover adopt the some arguments of my seniors, your lordships. But in addition to that, I make few additional, your lordship, for kind consideration, your lordships.
Okay.
The issue before my lord is that.
Can you complete within 10 minutes?
Yes, my lord, I will.
Okay.
The issue before my lord is that the goods which have been accompanied with a challan cum stock transfer invoice of excise invoices under rule 11 of the Central Excise Rules 2002.
Yes.
And also in terms of section 6A of the Central Sales Tax Act, read with rule 12.5 of the Central Registration Rules, account the declaration form is the invoices or it shall be not be invoiced but invoke the provision to section 2J of the Act for the purpose of valuation, your lordship. In order to substantiate my submission for 10 minutes, I will permit to share a comparison of the documents, your lordships, yes, for your time period, your lordships.
Yes.
I have stayed inviting to attention to my lord page 1 of my compilation, your lordships.
Yes.
That is the highlighted part that says delivery challan cum excise invoices, your lordships. It was issued under rule 11 of the Central Excise Rules 2002, your lordships. It contains many of the things, your lordships, and I am straight going to inviting page 4, your lordships. The highlighted part says that excise duty.
That is all right.
Page 4, my lord. Page 4, my lord.
Yes.
Excise duty says on excise duty and says at the rate of 1% also on the same excise duty. So this is the document which is prepared under rule 11 of Central Excise Rules, your lordship. We read with section 4 of the Central Excise Act, your lordship. This is the document on which the goods have been transferred to my base by the factory situated in Chennai to my branch at Bhubaneswar in the state of Odisha, your lordships.
Yes.
My lord, unlike the provisions of the GST Act age on date, my lords, that the theory of supply of goods and supply of services they come into force, your lordships. Under the Article Odisha Sales Tax Act, Central Sales Tax Act, there is no provision for that a branch office to raise an invoice, its head office, or a head office to raise an invoice in a branch actually, because there is no transfer property into goods on a term of sale is concerned. That is why, your lordship, the mechanism of stocks transfer under 6A of the Central Sales Tax has been incorporated, your lordship. My seniors already read out to section 6A, your lordship, but I was just want to invite your attention to the revisited section 6A of the Central Sales Tax Act, your lordship, is page 9, your lordships. Page 9, section 6A, marker with highlighted, your lordships.
Yes, go on.
It will prove to be only stocks transfer in case it is produced by declaration, your lordships, which is in terms of rule 12.5 of the lordships. And I invite you to consider the last 2 lines, your lordships, of the page 10, your lordships. And if the dealer fails to furnish such declaration, my lord, can you take note that of its lordship? Then the movement of such goods shall be deemed for all purposes of this act to have been occasion result of sale, your lordships. This is the same stocks transfer invoices received. This is the same excise invoices received. It is deemed to a stocks transfer if it accompanied to sale, if we accompany the declaration format. If it is not accompanied declaration format, then it is treated as sale, your lordships. That means on the same invoice, it is a sale. If not accompanied declaration, if it is accompanied declaration, then it is a stock transfer. My lord, kindly note that the value remaining the same, your lordships. The value remain unchanged, whether it is sale or it is a stock transfer, your lordships.
Just a minute. Mr. Would you reply? How many times? 3 minutes?
Your Lordship, my Lord and Seniors have taken much more time. Your Lordship, minimum 1 hour, Your Lordship. I have prepared notes.
Day after tomorrow.
Grateful, my lord.
List, day after tomorrow, all the matters, as part of the continuation of your.
My lord, 2 p.m., my lord.
Deputy tomorrow,
My lord, it can be posted next week, my lord, that will be convenient, madam.
Who is there?
Actually, I'm coming now. Maybe next week, my lord.
Therefore, do not come.
Monday, my lord.
Usually follow September 8th. The board the matter to drive that out of memory. One thing you do, if you can be even if outside,
sir.
you address this online.
Yes, better. Yes, correct.
And if it is not possible, then we'll think of giving another short date. But try to be online.
I beg your pardon, Lordship. One writ petition needs to be added into the batch. It has missed out. It has got missed out. I'll give the number. WPC number 22529 of 2012.
2259.
22529 of 2012.
Along with WPC number 6. Yes, matter.
Lordship at 2 p.m.
2 p.m.
Day after tomorrow.
Day after tomorrow, 2 p.m.
Yes, Mr. Roth.
Better list or specialist. WPC note 28155 of 2023.
Whether anyone has come from the.
I have served a copy on the Council for Municipal Corporations. Mr. Pradeep Pramanti usually appears. I have served a copy on the.
There is no standing council.
Yes, Madam Pradeep Pramanti and his son is appearing. I have served a copy on them. I have also said. Yes, Lord, he is coming. He is coming.
Yes,
Yes, Lord, my Lord.
Because we have sought for instruction, my lord, sir. Let it come, my lord, next week.
Very convenient with that. Have you read the petition?
Because in respect of one candidate only, my lord, their grievances.
No, issue is not one candidate.
One candidate, it's a life concern, you are saying candidate.
That is right, bro.
And one candidate is not like a normal human being like us. He's a challenged person.
Man.
He's suffering from 65% cerebral palsy, and also there is some, he always uses the stick.
We'll take care of that, my lord. Let him make the health officer as a party also. Health officer, he has made a grievance before him, and the health officer I could not contact. Health officer is suffering from dengue.
health officer is working on under the commissioner. I don't mind.
No, just make a party.
Yes, I don't mind. The health officer is working with the commissioner.
But this is, what is the reality is there? Dogs menace throughout the city.
No, but because
It should be taken proper care.
when there is a covered by boundary walls, these stray dogs are very dangerous sometimes. If there is a less food, because they have no other option.
Yes.
If they are scared, they will attack. And also because since I'm also involved with that university, different capacity, I know this issue is to this the people for animal, the famous NGO.
Yes.
They have also intervened in the matter. So now I think the university authority has ready that municipal group enters into the premises and picks up all the dogs outside for.
It's a great concern, in fact, a differently able person student has been bitten by dogs, a stray dog smeller, group of dog smeller. His life is in danger, in fact.
No, his life is dangerous because the dogs get scared.
Right.
Looking at his walking stick.
Yes.
That is the thing. So we direct you by 24 hours.
CMC has a dog squad, everything is there.
By that, what will be the direction? By tomorrow 4, you cleanse that premises.
Yes.
Take them to some other places and keep them. Because I am told that your CMC doesn't have the place to keep the dogs. They should create, because they cannot be just thrown out or killed. So they should be just removed out of the university campus. Right?
They're capturing the dogs, I find, but I don't know where they're leaving them. I don't know that.
No, they
removed from the campus. To be removed from the campus.
Now, removed from the campus, again they will leave it outside. Again they will come back.
No, not there.
Outside territorial, they have to be. The territory has to be.
They should be rehabilitated territory.
Yes, right.
Because other dogs in some other area, they will not allow to live there.
In fact, an application was made before this honorable court wherein all these relating to stray dogs, because what the municipality is doing is they are picking up at random. Even the ones which are already vaccinated and sterilized, they are also being picked up in a most unhuman, obnoxious manner.
No,
they are being taken, detained whenever the case happens.
No, this is not a bit different.
Stray dogs.
This is what stray dogs in a closed enclosure that should be shifted out, because otherwise what happens, these the boy particularly is suffering from 65% cerebral palsy. Issue about just using a walking stick to make the balance, and whenever the stick is seen by the dogs, they attacks. I am told by 7 to 8 times. And last night he was to hospitalize because of the chest pain and other squares.
Doctor said that he can suffer from heart attack malady in the shock.
Because primarily I am against replacement of the dogs, because they become more violent in some incidences there.
Sorry, Malda has not been 2 children were.
I know that. Because what happens when they do not get the food, do not get this affection from the co-residents.
Yes.
They think they are also co-residents.
They become wild. That's the.
In this honorable court, there is a case of Puri municipality.
Yes.
A dog totally killed a child.
So when they got scared, it's very dangerous. So, what is your exact prayer, Mr. Roth?
Lord, we have only prayed that, Lord, to relocate them.
Taken out of the campus.
Yes, that's my prayer is there.
But one thing is that I can't say, Lord, whether this guideline is applicable here or not. They must have the provisions under the Municipal Corporation Act.
Whatever, that our direction will be general in
yes, that your line.
We are not the guidelines or not.
In the prayer, my learned friend has made that to enforce that clause of annexure.
No, that's a different word. Only campus, to the extent campus.
Only purpose to be solved.
Yes, campus.
Only I pray, not health officer may be also involved.
No, you involve health officer. Why they should involve?
Your direction is Malad.
No, all right. He's your officer.
Right.
We'll issue order to him.
Because he is the concerned officer, has to enforce all these things.
All right, heard Mr. P.K. Roth from a senior counsel, stated by Ms. S. Das. But you have not spoken a word also. This is the matters where you should speak out.
Right.
And Mr. Pradeep Kumar Mohanty, from senior counsel, assisted by Pranay is Kumar or only Pranay Mohanty and counsel appearing for Court Municipal Corporation. So this is a case which we have considered requires urgent disposal. And accordingly, this matter has been taken on special notice. The principal relief asked in this public interest litigation is for removal of the stray dogs from the National Law University of Orissa campus, from the campus of the National Law University of Orissa, as according to the petitioner, quote, now those dogs, quote, are causing threat to life of Aditya Rai Chaudhary, a first-year student of NLUO who suffers from cerebral palsy and 65% disability. Stop. In the last 1 month, he has been chased by the stray dogs in the university campus 15 times and bitten 7 times. The last attack being on 26th August 2023. Just continue 7 times. The last attack being 26th August 2023. Stop. Often visible, unquote. The last attack being such and such. Each time he has to take anti-rabies injection. That is a fiction. Mr. Roth, from university, we do not like this kind of incorrect statement. Anti-rabies injections taken every time it was not to be given. It's a common knowledge. It is a series of injection is given, it covers. So they should be very careful in future.
I'll tell them.
Yes.
I'll communicate it.
It has been stated to us by Mr. Roth, the senior counsel. Now Aditya Rai Chaudhary has been suffering from acute anxiety and unstable blood pressure. Stop. His mental and physical health have been gravely affected by the series of incidents as noted before. On 27th August 2023, he had to be taken to the hospital for his unstable blood pressure. Stop. The university petitioner has stated that the dogs are not original inhabitants of the campus. They have migrated from the nearby locations like Brojo Biharipur, Naroj, etc. So they are to be recycled to their original habitat. And for that purpose, Court of Municipal Corporation should be directed for the immediate displacement of those dogs. Stop. It has been also stated in the application that, quote, the concerned student and his parents have been requested the university to ensure safety in view of the multiple chasing and biting attacks in the last 1 month. Stop. This is the 15-20 dogs that are obtained. From the evidence, it has transpired that 15 to 20 stray dogs had been involved in attacks, biting and chasing Aditya Rai Chaudhuri and the security staffs who rushed to protect him. According to the petitioner, due to ongoing mating season of dogs, the campus dogs have become even more aggressive. Stop. The petitioner has also stated in the petition that there have been attempts to sterilize those dogs, but those who are not completely successful. Therefore, the petitioner has asked this court to direct the Kotak Municipal Corporation to immediately return the campus stray dogs to their original habitat in the different villages. Following the guidelines issued by the Animal Welfare Board of India, which is available under Annexure 3 to this petition. Stop. The guidelines doesn't prohibit. The guidelines do not prohibit the recycling of the dogs to their original habitat. Mr. Mohanty Laner, Senior Counsel, appearing for the Kotak Municipal Corporation, has submitted that the Kotak Municipal Corporation has a squad for this purpose to pick up the dogs from the stray dogs from the streets and other places and recycle them to a place where they find the comfort and security relating to stay. Stop. But Mr. Mohanty Laner Counsel has asked this court that petitioner should have arranged the health officer, Kotak Municipal Corporation, as the party.
Grievance has been made to him.
But as the grievance was made by the university authority to him.
Annexure 1.
Stop. We have also seen the request made to the health officer, Kotak Municipal Corporation, on 7/8/2023, Annexure 1 to this petition. Stop. Both the council is on consensus that immediate action for displacement of the dogs is required. Stop. Having regard to the gravity of the situation and the consensus is formed between the council for the petitioner and the respondents, we direct the Commissioner, Kotak Municipal Corporation, to engage the concerned department, yes, and the health officer for removing all the stray dogs from the campus of National Law University, Orissa, from the Kadjuri campus of the National Law University, Orissa, within 24 hours from now. Stop. A compliance report be filed by day after tomorrow before this court.
Order copy may kindly be provided. Order copy may kindly be
sure. That will I stop. After serving a copy to Mr. MSS Das Learned Counsel for the petition. Stop. In terms of the above direction, this writ petition stands disposed of. Anything more?
One day more may be given.
Huh?
One day more may be given.
No, by 4th tomorrow.
No, we'll do that. We'll do that.
Just don't, because you understand why this time is given.
For filing compliance report. For filing the compliance report, kindly give 1 day more.
Day after tomorrow for compliance. I have already dictated that.
Okay, 1 day thereafter.
All right, if you cannot do that, you come to me, I will extend it. It is one case thing that you have complied. This is one and three coming. A copy of this order is served forthwith to Mr. Pranoy Mohanty and Council appearing for the Cuttack Municipal Corporation. Go and type it first. We are sending it. Pranoy, just wait for 1 hour in the court. List tomorrow.
So, there also the list will be taken over 2 o'clock.
We don't have the money for 2 o'clock because one matter is taken up.
I understand, well, I know that. But I was just requesting Thursday also. My friend is there.
All right. Let the matter with Thursday. Mr. Mukherjee,
he is there.
On Thursday.
Item number 51.
Mention 25.
Let us try again.
Item by item 25. Item 25. If your lordship could have it on any day for final hearing, the interim order has to be continued. This is about water charges, my lord. It will take some time.
All right. 12th of September, okay, Mr. Join?
Yes, 12th is fine. Interim orders may continue.
That will do it. Item 55.
No, 25.
25. Item 25. Past earlier shall continue in the next thing.
Sorry, it is possible to have it end of September.
Just 1 minute, just coming to you. Tomorrow? Day after tomorrow. All right.
Item 40, similar matters are listed in 5th of September, my lord.
All right.
W number, it can come along with W number 2023.
Item number
41, my lord.
41 along with W
2023.
All right.
Item 47, my lord. It will also take up on 4th, my lord.
It is not possible.
Or 5th and 2 p.m. This is the case where in root of them, they are challenging someone.
Understood, you mentioned the matter.
My lord, item number 21.
Just a minute. 11th of September 2023 at 2 p.m.
Lordship, item 29, Lordship. This is a matter pertaining to the PIL pertaining to the Chilka, Lordship. Your Lordship, it's a short date, because it requires some time. Senior counsel.
In fact, Lordship, in this matter, Lordship, we are attending item 29. So I think so what I think that's cases are very assumed. The public interpretation for some direction from the apex court and within the taking off. Last package the government does it.
So, we fixed it on 26th September.
But let's say the last package that they taken time to produce the Chilka policy or civil direction this on the court. Nothing is done.
How can he know that whether
What is the fixing word between yourself? 26 already.
26.
My opportunity kind of come to one big application. Despite nursing science direction. There is a nursing fraud which is there. They're not making some nursing because nursing. 4, 5, 3, 5 nursing that is.
That can be detached and can be listed on any other day.
So, direction. It can be demolished by judicial order. Instruction will suffice.
We are fixing this matter on 14th September.
14th September.
Also matters.
Yes.
Item number this item.
And everything is
at 2 p.m. Yes, there is no time today to take up the matter. The council's mention will be reflected. In the meanwhile, state opposite parties shall place the policy on Chilka.
Yes, we shall place our affidavit that whether the Chilka policy has been
we ask you to send the word. If you do not have the policy, how can you?
Yes.
But if the policy is there, you have to.
Yes. Obliged.
So it will coming on this 12, no? 14th September.
Lordship, your lordship, please.
My lordship, item 25 was just pleased to fix that on 12th, my lordship. In those matters, my lords, interim orders have to be extended, my lords. In all the matters.
Already there.
My lords.
So,
My lord, item number 21, one conversion petition has been filed for conversion of the nomenclature from WP-CRL to CRLMP, my lord. That is IA number 36 of 2023.
I number 36, take down I number 36, 2026. This is an application for conversion of the nomenclature of the petition from WPCRL to CRLMP. Peruse the amendments. WPCRL is converted to CRLMP. List is directed to re-register the case and place the case to the assigned bench. All right, you pass the order.
My lord,
I stand disposed of. Yes.
13 it will be taken next week, my lord.
All right. He will be giving the after seeing the date. Will
there, my lord. That will
give a date on next week. All right.
Status quo is to be maintained, my lord.
There is an order.
My lord.
Earlier order is there.
Yes, my lord.
Interim order, if any, shall continue till the next date to take these files and keep those things together. Huh?
Right. My lord, I may pardon the item 47 your lordship fixed to 11th September. Instead of 11th September, immediately thereafter, my lord.
Right now, if it's 11th September, then
the state appeal.
Well, it's 27th of September.
Public.
You just change it and inform who has taken the declaration. Take No, these judges are given the date.
12/9. Now,
you just let the matter come because the learned council is
I am for the appellant. State is the appellant.
Water matter?
No, 47. I am on the 47.
Oh, not is 47. He's on 25. So, all right.
At 2 p.m. my lord, that your lordship. At 2 p.m.
So you'll not come in the morning in the court?
Well, I will make mention on that day.
Okay.